That's okay. My lord, may I be permitted, my lord passed an order, my lord, on 7th, my lord. That order is till date not uploaded, my lord.
Please come on Wednesday.
May I be permitted to mention a matter for inclusion, my lord?
Please come on Wednesday. Yes, call the list.
Contempt file.
Wednesday. Yes. Item of 1, judgment, it will be pronounced at 2 p.m. Come back to see.
My lord, this is a section 24 application, my lord. It was sent for mediation. Mediation has failed. My lord, I am the wife. My lord, I am the wife seeking transfer from Barakpur to Chinsura primarily on 3 grounds. One of the ground is that, my lord, earlier, my lord, taking advantage of my inconvenience, restitution of conjugal rights, my lord, husband is armed with a decree of ex parte decree.
He never
Now,
appeared.
I had never appeared, taking advantage of my inconvenience, my lord. Now, my lord, he is pressing for divorce before the learned court at Barakpur. And my lord, all the pending proceedings, be it domestic violence, 125 proceedings, and the guardians and Wards Act proceedings are pending before the Chinsura court.
Yes, the husband has been acquitted. And domestic violence is pending, and Act 8 case is pending, and 125 is pending.
So you are contesting those
Those are
proceedings.
Lordship, kindly appreciate the husband is a school teacher. Every day he has to take a leave for the whole day from the school and has to come to Chuchro. But
Has to, even for appearing in the court where it is pending, he has to take leave.
the husband, your lordship, the child is staying with the husband.
Maybe.
Lordship, it is very
The husband is attending the school at that point of time where the child is staying.
school in his school.
So no problem.
Kindly appreciate your lordship. Chuchuro and Barakpur is not a great distance, your lordship. Chuchuro and Barakpur court is not a big distance, your lordship.
So it will not be difficult for you to travel there.
The husband has to take leave from school every day, your lordship. Kindly appreciate.
Has to. Because of even for the purpose of attending the court at Barakpur, he has to take leave.
In all the 3 cases, wife mostly does not appear. Every time she is giving adjournment petition.
Here also, if the wife does not appear, ex parte it will proceed. Yes, Mr. Banerjee, where are the other proceedings pending?
My lord would kindly take page 6, my lord, of my section 24 application. I have given the list, my lord.
All these are proceeding in Hooghly.
Yes, Hooghly. And my lord, the ex parte decree, my lord, that they themselves have averred at page 17, my lord.
Notice was served, but she.
Yes, my lord, I couldn't appear, my lord, my inconvenience.
17.
Paragraph, page 17.
Yes.
First paragraph on 25/8/20 after
Page 17. Yes.
Yes, my lord, the restitution of conjugal right was filed by the husband and it was decreed ex parte in the first paragraph, paragraph 18.
Paragraph 18.
Yes, paragraph 18, it starts from page 16.
Yes. So
thereafter, my lord will take page 20.
So, Mr. Banerjee, why are you not going back to your husband?
My lord,
There is
mediation had also failed. My lord, we tried our level.
Go back to your husband.
We tried our level best, my lord. It was sent for mediation. My lord knows it was out of her.
When the Section 9 was filed in 2024.
Yes.
And this proceeding filed in?
No, it was filed, man. Later it was renumbered. It was on 2021.
2021.
Yes.
The restitution of conjugal rights.
Yes.
And this proceeding has been filed in 2024.
This proceeding was filed in the year 2024.
This application under Section 24 of the Hindu Marriage Act, Section 24 of the Code of Civil Procedure, is at the instance of the wife praying for transfer of the matrimonial suit number 1622 আচ্ছা ওটা একটা লিখে দেবেন উপরে, though this matter since I'm not in,
Since January 2025, I'm asking for a copy. Since January 25, I'm asking for a copy. That can.
he's not giving. Mr. Mukherjee, I cannot pass any order. Since I'm not inclined to take up this matter on personal ground, this matter stands released from the list of this bench. Let the papers be placed before the Honorable Chief Justice for necessary order.
আমি জেরক্স করে দিচ্ছি।
Yes, next.
Four.
দেখেছেন? পিটিশন আপলোড হয় 7 তারিখে দেখে নিতে।
Yes.
Wait. More petition.
Yes. Who has mentioned this matter?
My lord,
Who mentioned this matter?
my lord,
Yes.
my lord,
What do you want?
no, I want a dismissal. Because this does not, the application does
No,
not.
this is appearing under the heading to be mentioned.
This is
What
by
for
your-
it is appearing?
This is by your lordship's convenience. We mentioned the matter so that the matter is heard out and our prejudices are gone. For
Yes.
1 year, the execution is pending. The learned court below passed a reasoned order. Then, my lord, challenging that this application has been filed with frivolous causes.
Yes.
Let them place and convince your lordship. I am coming to repudiate this same. The matter was supposed to come as a returnable motion in the month of February. But before the order was uploaded, the matter did not appear in the list. Then, my lord, we are suffering. There is a stay till April.
Yes.
My lord, kindly fix a date for final hearing, because I'm enjoying the stay till April,
Yes.
and there is
May I-
absolute
So, yes, madam, kindly proceed with the matter.
lordship. Kindly fix a date in the middle of April.
Not in the middle of April.
Lordship,
Why in the middle of April? Since you are enjoying an order of stay till the end of April, that is why you want in the middle of April.
Lordship, not
So-
for that reason. There is some personal difficulty also in the month of end
Tomorrow.
of March.
Tomorrow come to,
Lordship, I will not be available, Lordship, because
So
of my
then
father's
proceed
treatment,
today.
your Lordship.
then proceed today. Yes.
Lordship, kindly fix it in the next half. Lordship, I'm ready.
Next up at 2 p.m.
Lordship, I'm ready with the matter.
At 2 p.m. you want?
Uh,
Yes. 2 p.m. Yes.
এটা আমাদের তো
কস্ট টাইটেলটা ভুল আছে। No, বুঝতে পারছি না কি বলছেন। কোথায় সুকন্যা? ও সুকন্যা দে রয়, এটা হবে সুকান্ত। এটা না, সুকন্যা দে রয় না হয় এটা সুকান্ত হবে নামটা, সুকান্ত দে রয়। It has been pointed out that there is a typographical error in the cost title of these. No, it has been pointed out that a typographical error has crept in the order dated 20th February 2025 wherein the name of the opposite party was wrongly recorded as Sukanya De Roy, the inverted comma মধ্যে, instead of Sukanto De Roy. First of, let such error be rectified. First of, this order shall form part of the order dated 20th February 2025. Yes, next.
Six Madam, I am appearing on behalf of the District Primary School Council, North West Pargana, my lord. I am appearing on behalf of the District Primary School Council, North West Pargana, my lord.
Yes, District Primary School Council, this is contempt.
Yes, my lord.
Yes.
In compliance of Lordship's order, my lord, the District Primary School Council already sent to the file to the Commission of School Education for necessary consideration.
It has been complied with.
So, my lord, actually, they are harassing me. 1 minute. Now, this order was produced before loss on the earlier occasion. Now, can you see this order? One order.
17
order.
September 2022.
Now, this order was produced by Mr. Oscar Boiso on the earlier occasion. When I submitted before lordship. Kindly page 21, kindly see of my content application.
Yes, yes. This was produced on the earlier occasion.
But
As noted in the order dated 6th of February. All right, let him appear. Otherwise, I think he will not understand.
The matter is pending before the Commission of School Education, my lord.
This order was produced past an order of 6th of February 2025. So we are again producing this order.
But they're not caring. They are
Where is Mr.
harassing.
Boiso? What are you doing?
But initially, without giving any notice, hearing that was speak. You also told me, no, you appear, no further notice is to be given.
2 weeks adjournment was paid for.
Yes.
Where is Mr. Boiso? Ask him to come. Pass over. Take it back.
Well, let it be taken at 2 p.m. At 2 p.m.
2 p.m. Yes, next.
My lord, I may appear on behalf of the petitioner, my lord. Non-comply your lordship order, your lordship rule issue against the contempt, my lord. Thereafter, your lordship last order, 7 March 2025, rejection, alleged contempt as a service notice pursuant to the order dated 27 February. Alleged contempt is not present. Officer in charge Basundi Police Station is directed to ensure the presence of the alleged contempt next day. They communicate through the register. I may also have the
অর্ডারটা কমিউনিকেট হয়েছিল দি অফিসার ইন চার্জ
I serve the speed post, my lord.
করাচ্ছেন না কমিউনিকেট হয়েছিল কিনা দেখুন
Tag report is delivered, my lord.
দেখবেন তো এই রেকর্ড গুলো
I personally serve, my lord. I serve the copy of the your lordship order. The officer in charge. Tag report is delivered, my lord.
where is the affidavit service
Last
file a affidavit of service
my lord, today here now,
affidavit
here
of
now, here now.
affidavit of service
My lord.
আসুন it has been submitted by the learned paragraph, next.
Eight.
My lord, I am appearing for the petition. My lord, an order was passed, my lord, on 26th December. Allowing there for stay. This order was, my lord, the matter was directed to appear on 13th. 13th matter appeared, my lord, as returnable motion, but could not be taken up. In view of the fact, my lord, his lordship was not sitting on that day.
Ashun,
My lord,
can 1 of 2025
Lordship, in this matter, who is appearing for the petitioner, advocate is very suffering from very high fever with infection, Lordship. I am praying for not this week, Lordship.
Not this week.
Not this week,
A
Lordship.
judgment and decree passed in a title appeal has been challenged in a civil division.
Lordship. Over to-
Ashun. This application under Article 227 of the Constitution of India is directed against a judgment and decree dated December 9, 2024, passed by the learned Additional District Judge, 5th Court, Bardwan, in title appeal number 85 of 2017. First up, the said judge, an appeal lies against the judgment and decree. First up, in view thereof,
My lord, I am for the petition.
yes, Mr. Day.
This is a caveat, my lord. I have served the copy of the petition, my lord, upon the learned advocate, the caveat.
Yes.
This is a suit, my lord, filed by the plaintiff petitioner for the learned court below regarding recovery of possession on revocation of license. Written statement filed. Thereafter, issues framed, evidence started. During the time of evidence, when cross-examination was there, and exhibit number 10 was, the document was exhibited as exhibit number 10. Then, my lord, an objection was there from the side of the defendant.
After marking objection or prior to marking objection?
Marking objection.
Where is the copy of the evidence?
Evidence. Evidence. This is the portion, my lord, marked as evidence, but objection, title not pass.
Which portion?
At the top, my lord.
The deed was lying in the custody of my father. So objection was raised at the time of marking.
Yes, at the time of marking. My lord, thereafter, my lord, the defendant, my lord, filed an application for impounding of the document. Thereafter, I made the written objection, filed written objection.
What
that
was
was
done?
But
Impounded.
Kindly come to the impugned order.
Yes.
This is the deed of relinquishment.
Yes.
Deed of relinquishment, but in the year 1958, it was executed.
Yes.
And it was executed on duly stamped mallet.
That has to be ascertained whether it's duly stamped or
kindly
not.
see the impugned order.
For that, it has to be impounded.
Kindly, come
Let
to
a report come that it is sufficiently stamped. End of the matter.
Kindly come to the impugned order.
Yes.
Internal last annexure, mallet. Impugned the internal page number 3, mallet. Kindly
Yes.
see page number 3 from the bottom. The
Yes.
document which has been marked as exhibit 10 in the suit is a document of non-testamentary instrument by which the right of the suit property in favor of the Jyotindranath Bandyopadhyay has been extinguished. The Schedule 1A, Article 55 of the Stamp Duty on Instrument in the West Bengal Act states that release, that is to say, any instrument not being such a release as is provided for the Section 23A, person renounces a claim upon another person or as against any specified property. A, if amount value of the claim does not extend beyond rupees 1,000.
Court Fees Act, West Bengal Court Fees Act.
West Bengal.
You have a copy of the Court Fees
Yes.
Act?
Stamp act.
Sorry,
Right. This is a stamp.
Stamp Act.
আমাদের copy আছে? ছোট বই রাখতে।
Court Fees Act, na Stamp Act, Stamp Act.
The stamp duty, my lord, as of bond number 15 for such amount for the value as set forth in the release. My lord, this is the amendment of 1988, not prior to that, my lord.
Yes,
The basis on which, my lord, the document sent for impounding, my lord, not, the reason is not there, number one. And the,
reason, yes,
and my lord,
insufficient.
this is the 1988 amendment, not prior to that. So the observation which the learned court below stating, that is in correction 1988 amendment, not prior to that. The document registered in the year 1958. So nothing has been stated or no reason has been given why it is, my lord, impounded in the 1988 amendment. And my lord, if your lordship kindly come to page
When
number,
does it take into consideration the 1988 amendment?
kindly see page number 38 of their application. What is written?
No, from the impugned order.
From the impugned order, my lord. Only stated, my lord, says, my lord, the schedule number A, the learned court below referred article number 55 only. That it is a deed of release. For that, my lord,
By the
Lord, a short question.
এই
Lord,
আচ্ছা আচ্ছা
Lord,
তার আগে লিখুন আহ, আহ, affidavit sub-
come to
Page?
page 65. Lord, at the time of remand, Lord, remand was made by the appellate court to the trial court whether I am a Borgadar or not. Because my right as claim for preemption is as a Borgadar. Only restricted remand. Other points, my Lord,
page
maintainability.
65.
Page 65.
Show me that. Page 65, which portion?
Page 65. Lord, towards there is no dispute that the petitioner appellant is one of the legal heirs.
Which portion?
Quoted Borgadar. Bottom of the page. 65.
There is no dispute, yes.
Yes. Anil Karar and another son of Borgadar had approached this court claiming preemption of the property, not challenge the cultivation of this land by the appellant petitioner. What is not disputed, therefore, cannot be looked into or decided. The trial court, therefore, decided on the matters which were not in dispute between the parties. He has clearly departed from the principles of natural justice and decided the case on the matter which is subject to legal education but not related to the conflict and dispute between the court. In the light of the above, it is fit to set aside the order with direction to dispose by allowing the parties before him opportunity of face hearing but without opportunity of adducing of or producing evidence. Then, my lord, it will back to because no issue was framed regarding the Borgadarship. That is why, my lord, restricted demand was made. Lord, this has become final. Only to the extent, my lord, whether I am a Borgadar or not. Now, my lord, he decided with regard to nomination,
Mr.
15A,
Banerjee,
capital A,
give me a minute.
15 capital A. He had discussed. No issue has been framed. That is why. And this is the only argument, my lord, advanced by the appellant at that time. That is the preemptee. Appellant was the preemptee. Yes, page 64, provision deals with the
Mr.
procedure.
Banerjee, give me a minute.
Lordship. Restricted point. Lord, then,
Mr. Banerjee, take your seat.
Lord,
Give me a minute. Land Reform Sector to the Yes, Mr. Banerjee.
Lord, only point, my Lord, Abdul Motin Malik. Abdul
No,
Motin.
after this, what happened?
After this, my Lord, the trial judgment.
Yes,
My Lord, granting preemption,
trial judge allowed preemption.
allowed preemption. And determination, my Lord, with regard to issue number 1, Borgadar. Because
Borgada, it was found.
found.
Yes, held in your favor.
Yes. Now, my Lord, remaining point, my Lord, practically it will be allowed. Practical.
So why the miscellaneous appeal was allowed?
Miscellaneous appeal was allowed on the ground that the short deposit has been met. But that question, my Lord, is, Lord, that question I'm arguing. That question, me I arguing, my Lord. Your Lordship kindly look to Lord paragraph, because that part, my Lord, is principles of res judicata. Again, the remand order, no revision.
Maybe. But
But
the,
retrospective
Mr.
effect.
Banerjee, the
Retrospective effect.
initially your application was rejected at the threshold.
Hmm.
You could not prove your Borgadar, right of Borgadar, or that you are the Borgadar. The court did not enter into any other aspect. Was concerned whether an application under 8 and 9 at your instance claiming to be a Borgadar was maintainable or not. For that, it has been remanded. Now, after it has been remanded, maybe you have succeeded Borgadar merely because
But, my Lord,
of
yes.
the fact.
One thing, my Lord, the trial judge held retroactive, not retrospective, retroactive. He has discussed it.
What
With regard to the, because at the time when the preemption was filed in 2014, at that time this law was not there.
Mr. Banerjee, do you know the facts of Barasat Eye Hospital?
Oh, thereafter, my Lord, Barasat High Hospital, my Lord,
They are in the miscellaneous appeal. Direction was passed.
that is under the Bihar
That
Land,
was under challenge.
Bihar Land Reforms Act.
No, Barasat Eye Hospital is West Bengal Land Reforms Act.
No, under the Bihar Land Reforms Act. But that
I'm
was,
not on Bihar Land Reforms Act. I'm on West Bengal Land Reforms Act.
yes,
Barasat Eye Hospital, I argued that matter.
yes.
So there also, before the Honorable Supreme Court, it was pending. So during the pendency of the matter, direction was passed to deposit the amount of short
No, therefore, my
consideration.
Lord,
Challenging that. Thereafter, it has been held. No, nothing.
Lord, thereafter it was referred to a special bench.
Where it has been
referred to a special bench. It is pending before a special
Maybe.
bench.
maybe it has been.
Abdul Hudud, my Lord, that has been referred to before a special bench. Now, my Lord, what I am saying, Lord, of course, my Lord, I shall argue. I do not want to, Lord, claim any etagina. Lord, all the Lord, revisional application is kept.
That is entire share. Entire share, Mr.
No, sir, not entire share, short deposit. This is a
Non-notified.
yes. This is at the behest of the that is short deposit.
Short deposit also special bench has been constituted.
Constituted. Referred by Justice Bhattacharjee.
Give me that order.
Yes.
Give me the order of reference.
Yes. I am giving that judgment. Absolutely. Yes. Yes, Lord, kindly look. Lord, special bench, my Lord, larger bench, Dr. Justice Somen Sen, Subhoshachi Bhattacharjee and Obikishan Kapoor. Lord, bench is constituted and my Lord, this is the matter which is being heard. Lord, last page, your Lordship, kindly come to the last page. Last 2 pages. And Lord, so far as the short deposit in the case of a co-sharer or in the
This
case
is
of
co-sharer.
Lord, in the case
This
of a
is co-sharer.
no, in the case of a co-sharer, adjoining owner,
This is
Lord,
co-sharer, Mr.
Lord,
Banerjee.
may I, in the case of co-sharer, adjoining owner, and Lord, Borgadar, short deposit in all cases apply. Lord, short deposit,
That was a case of a co-sharer, but short deposit, my lord, in the
Mr.
case of
Banerjee,
a
if you want, I
borrower.
will give you a time. You can make your arguments. I will pass orders.
Very well, my lord, your lordship kindly, because your lordship kindly adjourn for a month, my lord.
Adjourn for a,
Adjourn for a month. I am not claiming any interim order.
why? Why adjourn for a month?
Because, my lord, it has already been heard.
Where?
And this is the question. What a Barkuna. Constituted, bench has already been constituted. Order has been passed. Here, kindly,
On the prayer of Mr. Banerjee, learned advocate for the petitioner, hearing of this matter stands adjourned. Yes,
lordship. I shall come back after that.
yes.
Lord, because after that, my lord, Abdul Motin, my lord, has totally, lord, what a special bench will do, I do not know. Abdul Motin, my lord, that is the whole difficulty. my lord.
Supreme Court judgment is there. When the Supreme Court
Lord,
judgment is
interpretation
there,
has been made.
Mr.
Lord,
Banerjee,
interpretation has been made in section 9. 9 has been interpreted by the
Mr.
Supreme Court.
Banerjee, those were the line of decisions, I think, starting from 72 or 78 Calcutta.
70, yes, my lord.
So
Lordship.
that was under the Bengal Tenancy Act,
Lordship. Under 26F.
26F.
Yes.
So starting from that, that logic was borrowed in 72 Calcutta, and that was the settled law, reversed in Barasat Eye Hospital. Only on that ground. And in Barasat Eye Hospital, I think your case is not better than that. There, a direction was passed to deposit short
Deposit, yeah.
consideration, reversed in civil revision.
Yes.
Reversed in civil revision, even then, that was not considered. After that, Mr. Banerjee,
Lord Abdul Motin Malik is also. Lord, because
it was after Barasat Eye Hospital. That is
after
the,
Barasat.
that is the
I
parent
see that.
decision. Abdul
the parent
Motin
decision.
followed Barasat Eye
So
Hospital.
yes, followed.
Followed Barasat Eye Hospital.
Lord, difficulty I understood. Only I wanted to show, Lord, that part is final, only to that extent. And he is waived
What
his
final? That is final up to the Honorable Supreme
remand
Court.
at the time of passing remand order, because retrospective and prospective, all Supreme Court judgment is retrospective, excepting in a case when it has become final. Because old judgment shall be effaced
Mr.
because of the
Mr. Banerjee,
subsequent
this is an
judgment.
interpretation. Law is there. It was interpreted in one way. Now it has interpreted in the other way. The earlier interpretation, the logic was why it is not to be paid now, because there is no provision for refund. That is the logic for which it was held. No, not at that point of time. Let the final adjudication be made. Thereafter, if required, you have to deposit, because on a assumption that there is no provision for refund, the Honorable Supreme Court has considered that and has held, yes, there is a provision for refund. Even if you deposit, if it is held at the time of inquiry under Section 9, can be refunded.
Supreme Court.
So that was the only logic why it was held, not at this point of time.
Abdul Motin Malik, my lord, he has specifically Supreme Court said deposit first. Then first stage is deposit. Second stage is serving summon. The third stage is inquiry. And after inquiry, if it is held by on adjudication,
You know what was the question put by the bench in Barasat Eye Hospital at the time of admission?
yes.
Are you aware? What was
Oh,
the
no,
question?
no, no,
posed?
Your lordship was.
Yes. Next. On the next matter.
Well,
Of what?
for eviction and the landlord payment. Application is still pending.
7-2. It's ready for hearing. Objection. This application under Article 227 of the Constitution of India is at the instance of the plaintiff paying for expeditious disposal of an application under Section 7 within bracket 2 of the West Bengal Premises Tenancy Act. First up, the learned advocate appearing for the petitioner submits that written objection to the application under Section 7 within bracket 2 of the said Act has already been filed, and the said application is otherwise ready for hearing. What is the date fixed for hearing of that application?
22nd of April.
In view of the order sought and proposed to be passed, there is no necessity to direct issuance of any notice upon the opposite parties. However, the learned advocate on record of the petitioner shall be obliged to forward a copy of this application along with this order upon the opposite parties or upon the learned advocates representing the opposite parties before the learned trial judge. Let us see what happens 7-2. It may go against you, you may have to challenge. So that order may cause prejudice to you. Yes, next.
I'm the petitioner, my lord. In an application under section 36 of the Special Marriage Act, my lord, the identity order, my lord, for maintenance, my past, my lord, 6,000 plus 3,000, 9,000, my lord, per month. Without considering that there is already an order passed in the 125 application for 5,000 payment to the wife and the daughter, my lord. My lord,
5,000.
yes, and he is paying, my lord. That has not been considered in this my lord, impugned order.
So
But and also the quantum is
the by the order impugned, the
it is not bearable, my lord. Husband
13,000 per month.
has not 11,390, my lord. At page C of the impugned order, bottom portion, the OP husband earns.
That is your claim. Court's finding is 13,390.
Yes, yes. So, my lord, my lord, 14,000, my lord.
I've seen that. Yes,
9,000,
call the next matter.
14,000 plus.
Sir, I've seen that. Yes, next.
Your lordship is for
That
petition.
is your claim, 11,000.
Admit-
Court's finding is 13,390. You are employed as a driver in the Kolkata police. Yes, yes. Call the next matter. Sir, please pay. Nothing will happen.
Mr. Shonak
Maybe
Bhattacharya-
adjust it.
Mr. Shonak Bhattacharya is appealing for the petition, your lordship.
Since I'm not inclined to take up this matter on personal ground, this matter stands released from the list of this plaint. Records be placed before the Honorable Chief Justice for necessary orders. Next.
15 lordship, short deposit. I was only trying my luck whether the pendency of the special bench will help me or.
As paid for by Mr. Royal and advocate for the petitioner. Yes, next.
16. I'm for the plaintiff petitioner, my lord. My lord, the suit for declaration and permanent injunction. The defendant opposite party number 1 only contested the matter. My lord, the suit for declaration declaring the co-schedule property, which is the part and parcel of co-schedule property, and the defendant have no right, title, or interest. And another declaration for declaring that the gift deed executed by one of my predecessor who have issueless couple not been acted upon, and false personification.
Where is your plaint? Where is your amendment application?
Yes, my lord, plaint, my lord, the kindly page number 19.
19.
19. My lord, the prayer, my lord, kindly see the prayer, page number 27.
So give deed is under challenge.
Yes, one give deed.
So now, where is your application for amendment?
Yes, my lord, the amendment application, page number 43.
43.
43. My lord, the WS file
Give
2006.
me a minute.
Madam, kindly see paragraph number 3 and 4. Madam, the WS, my lord, my lord, the defendant number, my lord, the contendant, there is a settlement, Solenama degree in the year 1965. And this was the first time I came to know. And thereafter, my lord, the document sought for from the defendant number 1, they not produce. Thereafter, on 2022.
So thus, when you came to know about this deed or this decree, Solenama decree, when did you come to know?
When the WS is filed partly and the
When the WS was filed?
Filed 2016.
2016.
And when
So you came to know in 2016.
Well, there is no details. Thereafter, I pray for production of documents, Solenama degree. Not then. But thereafter, in the year 2022, by a additional written statement, the defendant number produced certified copy of the deed. Then thereafter, I filed this application 24.
The particulars of the Solenama degree was stated in the written statement.
Written statement.
What prevented you from obtaining the copy thereof?
Not particulars. Kindly see the
Show me that.
Kindly
The
see
written statement.
Yes, kindly see the page number 1, order annexed here, my lord. Kindly see, there is a statement. Orderটা কোথায় দিনা? Orderটা দেখো। orderটা মোড়া আছে, orderটা দেখো। ও বাবা। orderটা কোথায় গেল?
2016 they have filed the
additional written statement filed
12th of September 2018. The defendant number 1 filed the photocopy of the compromise decree.
Yes, photocopy.
So yes, 2018 you were aware of this.
My lord, 2018 I am aware.
When did you file this application?
Yes, 24, my lord. So 2024. My lord, kindly see.
What by limitation, Mr. Das?
No, my lord, kindly see.
What is the period of limitation for challenging that decree?
My lord, maybe the 3 years. My lord, kindly see the following the judgment. My lord, the say Raghu Thilak, my lord, lordship better than me. The section limitation, if any, there be at the time of decided at the time after the amendment.
If there is a dispute, it is not a dispute because this was disclosed. This was disclosed. This is a decree of 1968 entered into between the predecessors in interest of the plaintiff and the defendants. So your predecessor and the defendant's predecessor, they entered into compromise decree.
No, I have no knowledge. I have challenges these. I have not acted upon.
Mr. Das, I am not saying you had knowledge, but it was a compromise decree entered into between your predecessors and the defendants.
Other petition.
So now,
No, defendant's petition, not defendant petition.
your predecessor,
Defendant is an outsider of my family.
your predecessor entered into the compromise decree.
Yes.
That is your statement, paragraph 3.
Yes, this is the allegation.
Kindly come to paragraph 3 of your application.
Lordship,
So also মোকদ্দমার বিবাদী বর্ণনাপত্র বাদীর বিবাদীগণের পূর্বাধিকারী মধ্যে. So your predecessor, defendant's predecessor.
Here the allegation. I have dealt with my amendment.
Mr. Das, is your statement, not their allegation. Kindly come to page 43. Your application, paragraph 3, which you are placing.
Yes.
It's your statement, not their allegation.
Well, after the filing of WS, I have amended the application, my plaint. But this is the fact. And my lord, I have not dealt with the specific.
2018,
no,
you came to know 2024.
Well, kindly consider when the the additional written statement was filed, then my lord, I have amendment application. Kindly consider it, page number 48. Page number 48, the additional WS file, in this regard, Solinama in question, I have then, my lord, after the particulars given by the defendant,
Particulars were given in 2018.
my lord, there is no date of.
Mr. Das, photocopy of that was filed.
Yes, my
Kindly
lord,
come to the order, impugned order.
but the
Kindly come to the impugned order, page 3.
one of
First
the,
after the bold portions.
yes,
Coming back to the instant suit, kindly place that loudly.
kindly see the one of the order by the passed by the learned judge.
Mr. Das, kindly come to the impugned order. Tell me whether there is any wrong recording of fact.
Yes.
Kindly come to after the bold portion at page 3.
Yes, but not, there is not the additional written statement, not the,
Maybe,
not made up.
maybe.
Kindly the additional written statement.
Maybe.
Kindly see the last, my lord, the particulars of the Solinama, my lord, the produced.
Mr.
Before-
Das, if the photocopy has been filed, what more do you want?
Yes, my lord, these are the, my lord, 2018. My lord, kindly consider
So, and
my lord, what
2024.
2024. My lord, unless it is amended, my lord, my plaint is infractuous because of Solinama. My
No.
lord, this is the, my lord, kindly see
Your
the,
plaint stands on the gift deed by way of false personification.
no,
So,
my lord, kindly see, my lord, kindly see the additional written statement. Kindly
Maybe,
consider. My lord, additional.
I accept your submission in
No,
the additional written
sir,
statement they have
My lord,
taken. But
my lord,
these
the
facts are not
No,
disputed.
my lord, the additional written statement, there is a particular, and one order, my lord, kindly the consider passed by this honorable learned judge. Orderটা পাচ্ছি না কেন? দিয়ে বল দেখা না। Kindly consider, my lord, one order passed. There is no particulars given by the defendant number 1. Learned judge also mentioned. Kindly see.
বসুন, বসুন।
বাবা, ধর না রে, এক পাতার order আছে, এক পাতা। এই যে, my lord, kindly see page number 42. 42. One of the order. My kindly is the last portion. Order dated 15/3/2022. 2022, page number 42. The last paragraph, on perusal of the said extract copy of the order being number 46 such and such, it appears that the court's name was mentioned properly, but the date of disposal and the date of receipt thereof by the district record room was not mentioned. Well, these are the defect. Well, there is no particulars given before the additional written statement was filed. After this order, the additional written statement was filed. Then I go file application for amendment. I have no, has been a delay, but not more than 3 years. My lord, I am the proceedings, and the proceedings in my lord, instead of the defendant number 1, who only contesting the defending the suit, others not defending the suit. I call for record. Prayer is made. Call for the record of the district judge Solinama degree, including the all relevant records. I challenged it, and by way of this, I filed the application, my lord. And this is my prayer, my lord, for amendment to be incorporated. Only the
When
consequences.
you came to know?
My lord,
When you came to know?
order, my lord, Solinama.
Where have you stated? When you came to know?
Came to know my knowledge by 2016, my lord. Yes, it is fact, my lord. But there is no particulars. I have made.
When you came to know of the particulars, full particulars,
22 additional.
you are having a copy of that deed now?
Yes, additional.
that.
No. Deed of deed. Solinama deed.
Yes.
There is no original file. Well, I have a copy, but inter file is not here, my lord.
Produce that.
Yes.
Bring that
I
copy
will
of the-
produce my adjourn today.
Prayer of the learned advocate for the petitioner, hearing of the matter stands. Now,
Only-
Mr. Das, learned advocate appearing for the petitioner, seeks an accommodation to produce the certified copy of the Solinama deed,
Yes.
which is the subject matter of the application for amendment. So stop as paid for by Mr. Das, hearing of the matter stands adjourned. Yes, next.
Date, my lord, the only date, the 3rd of April, my lord, the last chance, my lord, for PH. My lord, kindly see before that, any day, lordship, lordship. Maybe.
What will happen?
No, I will be difficult, my lord. I will be difficult. My lord, any day.
The hearing motion next week. Yes, next.
Next week, 17. Grateful, lordship.
Yes.
Grateful, lordship.
Yes.
The defendant number 1 is the petitioner before your lordship. What happened, my lord?
a suit is being initiated for recovery of money, it is not in respect of a insurance, fire insurance policy. Not in respect to that suit, not while not examination of the defendant was being going on, the DW3 is the licensed surveyor. Not after the incident took place, he gone there and survey. What is not the effect of not this fire destroy? What was the position? He has not submitted a report regarding that to prove that not I asked that DW3 to come on dock. Not he is the licensed surveyor. Not empanel.
You are the insurance company.
I'm the insurance company, defendant number 1 in this suit. Then the summon was also being issued, but by one way or the other, that particular witness is not facing the dock. I filed an application. He even mailed that he has certain difficulty, medical issues, all those things was taken into consideration. I filed an application so that this can be done on commission. That application of mine was being rejected, which is pending before this honorable court. Item number is 14. 1492 in the monthly.
1492 to baat karu.
And today, this revisional application is since that earlier revision is being pending, I must be candid. The coordinate bench of this honorable court once takes up this, the learned advocate entered appearance on behalf of the opposite party, and as usual, prayed for copy to be served on that account. This was being adjourned. This is the order in respect to that revisional application.
Who is the learned advocate?
Subroto Mukherjee. Now, the difficulty is that by virtue of this order impugned in this revisional application, my entire evidence is being closed. If your lordship once takes up order number 90.
So accepting DW3, who are the other witnesses in the list of witnesses whom you want to produce?
This is the last. No, if DW3, I prayed for.
You said your entire evidence has been closed. That signifies that there are other witnesses. So this is your last witness. What can be done, Mr. Mukherjee?
It has been posted for argument on 11th. That's why kindly gives me a breathing time. I know this is a commercial shoot. Fixes in the month of April itself. I shall come back. Not only with regard to
all your arguments in the commercial matter.
That's why I remind you.
That is playing in my mind.
I know. That's why. May I give me 50?
More so,
I shall come back.
More so,
I can also
show me the order by virtue of which
order number 90.
Page. The earlier civil division application was under challenge. You have not annexed that order in this civil division application.
This is yes. Page number 114.
Yes, 114. I am at 114.
Yes. Kindly look.
Yes.
The entire effort of mine regarding calling that person to come on dock is being recorded by the learned judge. Thereafter, the provision of Order 26 Rule 1 is being quoted. Page 117 onwards, your lordship.
He or she is your surveyor, Mr. Mukherjee.
Licensed surveyor. No, panel surveyor. I must.
Your surveyor.
Yes. But the report which has been submitted by him is not, it is something which needs to be proved. Otherwise, the 8 crore and odd is the amount which has been claimed. This is something which is what was there after the fire incident took place at that.
The surveyor is under your control.
Not at all. Kindly looks at even the surveyor stated.
Have you paid for issuance of witness summons?
Yes. Summons
was allowed.
Yes, allowed once we should recorded in the order in the earlier revisional application. This has been recorded.
Where?
After he mailed that, yes, due to some health issues, I am not unable to present the court. Kindly fix another day.
So where is that recorded in the earlier order?
Yes, kindly takes up the first page itself. The defendant has submitted from the first paragraph. May I just place before your lordship?
Yes.
The defendant has submitted the name of such and such as a witness in this case who has issued survey report pertaining to the case. 19th December 2023 was the date fixed for evidence of Ashish Pal of DW3. On the said date, Ashish Pal was out of station, the matter was adjourned, and the next date of evidence of DW3 was fixed on such and such. Due to the personal inconvenience of the learned advocate for the defendant, the date so fixed on such and such were rescheduled to the next date of evidence of DW3 was fixed on such and such. On the next date, on such and such, DW3 once again did not turn up, and an application under Order 26 Rule 7A of the Code of Civil Procedure was filed by the defendant. The said application was allowed, permitting the defendant to effect service of summons, as you got it below, to the Mr. Such and such by register post. Although summons was duly served, DW3 once again did not turn up to depose, and on the contrary issued email to the defendant stating that unless an amount, now your lordship will get how he is my witness, 6 lakhs and odd is to be paid to him, he will not appear to the court to depose. In such a situation, the defendant filed an application for issuing fresh summons on DW3. Such payer was also allowed on such, and fresh summons was issued to the DW3 through court. After receiving the summons, DW3 sent an email to the court requesting another date on the ground that he was experiencing health issues, especially such and high blood pressure. Taking into consideration of the health issue, the DW3, the matter was adjourned on such and such. Unfortunately, on that date, also DW3 did not turn up. And in such a situation, the defendant has come up with the present application. So, the entirety thing has been narrated. Now, your lordship knows, once the court has been directed, the party to issue a summon, and the requisite was put in spite of the receiving summons, if that witness did not come and appear and attend the doc, there are procedure, the court can ensure his presence. Instead of that, what I filed an application stating that without going into all these aspect, let a commissioner be appointed and the deposition can be done in one day itself.
So the court has to take these steps.
Yes, in either way. But without going into all these aspects, if on my application, our advocate commissioner can go there and record his deposition by one day, it can be done. It can be finished.
Did you file that application before the?
Yes, that was being rejected by the order impugned in the earlier revisional application, which I have just now placed before your lordship.
Where is the learned advocate who is appearing? Mr. Subroto Bhattacharya?
But I can give serve notice, I can come.
When this matter is taken up for hearing, Mr. Mukherjee, learned advocate appearing for the petitioner submits that another civil
But can it be on 25th? 24th, my learned friend has some difficulty.
25th, I can put it. So
no, your lordship. Great.
As defendants in a suit for declaration and injunction of the petitioners before your lordship, my application under Order 7, Rule 11 for rejection of plaint has been dismissed.
In all suits, Order 7, Rule 11 are found nowadays.
No, this is a suit, probably the best suited suit where the plaint should have been rejected, on two scores. Firstly, there was an earlier decree of 1910 wherein the forefathers of the plaintiff has abolished all their rights in respect of the property. Secondly, there was a earlier suit filed of 1994 which was dismissed for default.
So barred by res judicata.
Barred by res judicata.
So
No.
can it be decided under Order 7 Rule 11?
Yes, my lord. My lord, I have one judgment of the Honorable Supreme Court to that effect, and also of the bar contained under Order 9, Rule 9, my lord, because the earlier suit filed in 1994 on the same cause of action was dismissed for default. Restoration thereof filed but not pursued. Those were the two grounds taken out in the Order 7 Rule 11 application, my lord. The court returned.
Points were raised in course of hearing of the Order 7 Rule 11
Yes, my lord.
application.
The court.
Show me how it was dealt with by
Yes,
the
my
learned
lord,
trial judge.
the court.
Bar under Order 9, Rule 9 and res judicata. Show
Order
me.
9, Rule 9 not dealt in the impugned order, my lord, so far as.
So you have raised those points.
Yes, my lord. Kindly have
So
my.
file a review application. I am giving you liberty to file a review
Review will-
application. That cannot be decided here. If you have said you have raised those points,
Lord, is
not
there in my-
taken into consideration,
My lord, in that even, my lord, kindly set aside the
you
order.
have to take other recourses.
No, my lord, so far as review is concerned, my lord, the court did not return a finding on my Order 9, Rule 9.
But you have raised.
I have raised it.
So raised cannot be decided here.
Look, in that even, my lord, your lordship have to set aside the order and then.
No. That is not the law.
Lord, probably, my lord, the scope of review will be limited so far as it would not be, and because the judgment of our honorable court that if a relief is not granted, then other things are deemed to be rejected. My lord, on that score, my application will.
I will give you liberty to file a review on that. On your submission that some submissions you have made not recorded in the impugned order.
And that will also limit my window, my lord, so far as the case that the earlier decree is there of 19.
That I will, whatever you have made, I will not say anything.
That has been decided by the honorable, the learned court below me.
The earlier, show me that.
Yes, my lord. You kindly have the impugned order.
Yes.
26th of September 24, my lord.
Yes.
My lord, the third paragraph of the order, my lord, I have filed an application under 711D, read with section 151, paid for rejection of plaint with exemplary clause on the ground that the plaintiff are not shivais of the reverted property and they have no right title interest over the property. There were several suits instituted in respect of the said property. The section 34 of the Indian Trust Act is not relevant, my lord. Kindly thereafter, kindly sees that the plaintiff has referred to a judgment, my lord. This is the judgment of the Allahabad High Court, wherein it is stated that a Solanama decree is a contract and nothing more than a contract. And thereafter, the court has returned a finding that because it is a contract, 711 not attracted cannot be decided at that stage. But subject to correction, my lord, it is not only res judicata, but it is also estoppel by a judgment of a court. Which is
those can be decided.
Yes,
Under Order 7 Rule 11.
Yes, my lord. Suppose, my lord,
Order 7 Rule 11D place Order 7 Rule 11D.
The bar under law is also a bar created by a judgment of a court.
Yes.
So today, if there is a judge,
how the res judicata will be decided? Unless the pleadings of the earlier suit, the judgment of the earlier suit
was there
on record.
Was there. I had annexed it to my application.
Maybe you have annexed. But that cannot be a ground to decide.
May I persuade your lordship by just one paragraph?
Yes.
So just para 13. Kindly have para 13, my lord.
Para 13.
Yes, my lord. 1-3. At page 697 of the report.
This was on Order 7 Rule 11.
Yes, my lord. Kindly have, my lord.
Show me.
Well, I'll just check whether it is under Order 7 Rule 11, but it is barred by res judicata that has been held.
Sir, I am on Order 7 Rule 11, this issue of res judicata. Show me that it was under Order 7 Rule 11.
Let me check.
Upon the issues being framed, the learned civil judge found that the suit was not barred by reason of the decision of the previous suit. So it was upon a contested hearing, an issue being framed.
Yes,
so I am on that under Order 7 Rule 11. This is not a judgment under Order 7 Rule 11.
So far as the issue of
that these are the issues which are to be decided after
Order 9 Rule 9, my lord. Order 9 Rule 9, there is an earlier order of dismissal.
That the order has to be brought on record.
I had before the learned trial court.
It is not the procedure, sir. Sir, let us assume that along with your pleadings, you file all the documents which you are trying to rely upon. So there is no need to tender those and for those documents to be marked as an exhibit.
I am only on.
What are you suggesting?
I am only on the issue that whether a bar under Order 9 Rule 9 can be taken into consideration at the stage of Order 7 Rule 11 or not.
Show me. that it can be taken up under Order 7 Rule
There is a
11.
clear bar under law under Order 9 Rule 9, my lord.
But I'm not saying there is a clear bar for those. You have to produce what is the suit for, what was the order passed. So that can be decided.
I had produced the
Sir,
plaint.
Order 7 Rule 11D says from the statement made in the plaint.
But I understand, my lord, but there are, your lordship knows better than me that there are judgments of the Honorable Supreme Court that if
Show me those.
it is an effect of clever drafting.
This is not that. Show me those.
My lord, let me come up with those judgments. My lord,
After some argument, the learned advocate appearing for the petitioner prays for an accommodation. First up, as prayed for by the learned advocate. Yes, next.
returnable only.
Will appear. Yes, next.
Grateful.
Yes.
My lord, this is my lord. I'm waiting for the petitioner, my lord. My lord, the suit was filed, my lord. The second round of litigation, my lord. First of all, my lord, suit was filed under Arbitration Act, my lord. And my lord,
What do you want?
my lord, I filed.
What is
for,
your
my lord,
prayer?
Here, my lord, the suit is not maintainable at present, my lord. Because, my lord, I filed an application under section, my lord, 100.
That will be decided here, whether the suit is maintainable or not. Any application pending on the issue of maintainability?
Lordship, 151, 151.
Where is that?
My lord,
Where is that application?
Lordship, I'm doing that.
Which page? Why the suit is not maintainable?
Lord, before my lord order, my lord, Lordship kindly come. My lord, suit is not maintainable, my lord, because my lord, agreement expired, my lord, because my lord, development agreement was executed, my lord.
Please use the microphone.
My lord, development agreement was executed between the parties, my lord. My lord, for construction of a building, my lord. But that was not made, my lord, within the time period frame, my lord. And my lord, thereafter, my lord,
No, why the suit is not maintainable?
suit is not maintainable, my lord. My lord, second time suit was filed, my lord. Honorable High Court, my lord.
Where is your application under 151?
Before, my lord, order, my lord. Just before this.
What happened to the application under Section 8 of the Arbitration Act?
My lord,
You filed an application under Section 8 of the Arbitration Act.
Lordship, that,
What happened to that application?
that was rejected, my lord. Against
Rejected.
Against that order, my lord, I came before my lord High Court. Honorable High Court in
What happened to that?
Civil Division, my lord.
Yes.
Lordship,
What happened with the civil division?
my lord, in the Civil Division, my lord, interim order, ad interim order was vacated, my lord. Your lordship,
That civil division is still pending.
no, lordship. This was of, my lord.
It's fixed on 7th of April on the point of maintainability. So I'm directing
Lord,
the
several dates have passed, my lord. Because, my lord, it is
this
delaying, my lord.
this
2007,
application
my
under
lord,
Article 227. Yes.
On the petition, my lord, I only pray for expeditious disposal because
Of what?
of the suit, my lord, pending before the learned court below, my lord.
This application under Article 227 of the Constitution of India is at the instance of the plaintiff. What is the nature of the suit?
For declaration that the defendant is a rank trespasser, forcefully
In a suit for declaration of title and permanent injunction, praying for a direction upon the learned judge, 9th Bench City Civil Court at Calcutta, to dispose of title suit number 304 এসে গেছে তো? Yes, call the next matter.
Lordship, I for the petition.
Yes.
Lordship, the plaintiff is the petitioner before your Lordship. In this revisional application, Lordship, we have challenged two orders. Lordship, the first order, whereby Lordship, order number 52, Lordship, where the evidence of PW3 was closed. And Lordship, another is the part of order number 59, Lordship, whereby I filed an application for modification of the earlier order, along with an application captioned under order 26, rule 10. Those applications were rejected, Lordship. Now, Lordship, what happened? In the suit, Lordship, I filed a suit for declaration and recovery of possession, Lordship. In that suit, Lordship, an application under order 39, rule 7 was allowed. The Lordship, the commissioner, Lordship, filed a report, Lordship. Now, Lordship, during evidence, I wanted to get that document marked as exhibit. The defendant raised objection.
Order 39, rule 7 filed in aid of injunction.
Not in whole, Lordship. I have the application, Lordship.
In aid of injunction?
No.
Where is the application?
Yes. Lordship, the application is at page 22. Paragraph B. In order to facilitate this learned court and to better appreciate regarding the nature and character of the suit
So
property.
it's in aid of injunction.
Whatever.
What is the prayer in the suit?
Lordship, this is for declaration of title and recovery of injunction, recovery of possession.
Whether it is necessary, this local inspection for the purpose of deciding the issues in the suit, which is a suit for declaration of title that is to be proved based on documents or other oral evidence. And recovery of possession, also possession has to be proved by way of evidence.
True.
So how the report of the local inspection commissioner will help in adjudication
But
of the
Lordship,
issues
what
in the
happened
suit?
when I wanted it to get it exhibited, Lordship, the defendant raised objection and Lordship will kindly come
That is a different,
to page 34.
no, I appreciate that. There is an objection, but how that will be relevant for the purpose of deciding the suit, issues in the suit?
He decided, Lordship, in trial.
How? This is a suit for declaration of title. Title cannot be declared on the basis of the local inspection commissioner's report. Second is recovery of possession. So you have to show their possession. That is also
There
has to be
is
decided.
Lordship in the report because Lordship, the opposite party is
Maybe
also
I'm asking you how it is relevant in the suit.
Lordship, we can rely upon it. Lordship, why it is relevant, Lordship, that will be argued by the plaintiff, Lordship, in the suit. Lordship will kindly come to page 34, Lordship.
Basically, from the application, it was in the for the aid of injunction.
But
that is well over because that might be at that time you are saying that they are trying to change the nature and character of the suit. For such purpose, order
No,
39 rule 7 was allowed.
Property, Lordship, was there in the report, Lordship.
Yes, maybe. How that is relevant? Because you want recovery of possession, whatever it
Maybe,
is.
Lordship, that
you-
is another piece of evidence, Lordship, in support of my claim.
Yes, I appreciate
That
that.
will be, Lordship,
That will be
decided.
another piece of evidence.
Yes.
The report of the commissioner is not sacrosanct.
True.
That will be only a piece of evidence which will be considered along with the other evidences that will be produced by the
Yes.
parties. But how that will be relevant for the purpose of deciding the issues, which is a suit for declaration of title and
But
recovery of
Lordship,
possession.
not, Lordship, limit me from, Lordship, marking a document as evidence. Lordship will kindly see at page 34, Lordship. The learned trial judge directed the
What happened? The commissioner
the commissioner, Lordship, thereafter got married. She was a lady and she went to Delhi. And Lordship, at page 34, Lordship kindly comes. the court directed the commissioner to appear as PW3 through VC. Now, Lordship, at that time, on the
Now
day,
can he now give evidence through VC?
yes, yes. On the next date, Lordship, I filed an adjournment petition. Lordship kindly sees at page 35, paragraph 2, that thereafter the plaintiff has duly communicated the said order to the learned commissioner, but she stated that she was suffering from various gynecological problems and were treated under renowned gynecologists at New Delhi, and as such, she is unable to adduce her evidence today. She is under
That was in
treatment.
January. What is the position now?
Now, Lordship, she,
Mr.
yes.
Koti, because the suit will get delayed. Or because kindly
Lordship,
consider if it is not, maybe one day, if it is not necessary, you can take instructions on this. Apparently, from the scope of the suit, it does not appear
But
that
Lordship,
this
they are
local
interested,
inspection.
otherwise they would not have filed this application, Lordship. It was,
That
if it
was
was not necessary.
That was in aid of injunction. That stage is over.
True, but still,
Now
Lordship,
it's
they want to mark it as
injunction. I
exhibit.
think it has been decided one way or the other.
Yes, yes,
So
yes.
this was in aid of injunction. How that will help you? Because this will only
It will
delay your
strengthen
suit.
my case, Lordship.
It
It
will
will
only-
strengthen my case.
How?
With
How
another
in the suit?
evidence, it will be also another piece of evidence.
Yes.
Now, Lordship, how that,
But
Lordship, I shall
finally
argue
come to the
argument.
because the points of local inspection.
Yes.
If you go through the points, if you are just page 22.
Yes.
This commission work, raw materials, how that will go to strengthen your case in the suit, which is a suit for declaration of title and recovery of possession. These are the points on which the report has been filed.
True,
So
Lordship.
this will delay.
But whether, Lordship, these things will, Lordship, prevent me from, Lordship, marking a document from exhibits, Lordship. Whether, Lordship,
I
how
appreciate
far
that, but
Lordship,
I'm asking you how that is relevant.
but
If
how
it
far,
is-
Lordship, when a
Can I
document is
irrele-
marked
can I-
as exhibit, we don't, Lordship, value its evidentiary value. So, Lordship, at this stage, Lordship will kindly not evaluate its evidentiary value, Lordship. That will be decided at the time of argument, Lordship. Let the plaintiff at
Considering
least,
the scope of the suit,
yes.
so this cannot be relevant.
But, Lordship, whether this can be, Lordship,
How? I'm asking you how.
it will strengthen my case, Lordship.
How? Cannot strengthen your
Because,
title.
Lordship,
Cannot strengthen your title. What you have to prove, and this cannot be taken into consideration for the purpose of proving your title.
no.
Also, with regard to the possession, also it cannot be
Possession, yes, Lordship.
possession. Also, it has to be by way of evidence. Not
It will be also a piece of evidence, Lordship.
can the local inspection commissioner, on the basis of that possession, can be decided.
Lordship will not prevent, Lordship, my client from adducing this evidence. While, Lordship, during evidence, Lordship,
Have you taken
evidentiary
instructions
value-
whether she can come now?
No, Lordship, now my prayer is either she may be allowed to appear on virtual platform, or, Lordship, the advocate
The
commissioner may-
virtual platform that was allowed.
Yes, but at that time she was ill. That is why she could not allow, Lordship. The adjournment petition was also filed, Lordship. I just placed the adjournment petition,
Yes.
Lordship, at page 35.
That was on 7th of January.
Yes, thereafter now, Lordship, I have filed this application for modification. Lordship will kindly come.
Where is the application for modification?
Yes, that is at page 39.
39.
Yes. At paragraph 5 at page 40, Lordship, I have stated that the learned commissioner stated that since her marriage, as she is suffering from various gynecological problems and
Now she is ready to adduce her evidence through
through
VC.
VC or, Lordship, an advocate commissioner may be sent, Lordship, for on commission, whatever, Lordship.
How that has been dealt with?
Lordship will kindly come to the later part, Lordship, of order dated 59, dated 24th of February 2025. It is stated that, Lordship, several opportunities were given to me, but I did not avail. That is why, Lordship. And moreover, Lordship, I did not produce any medical documents.
By the order dated 7th of January 2025, the
My petition, my lord.
Yes.
In a
Mr.
suit for declaration, injunction, and recovery of possession, the defendant is the petitioner before your lordship. The process
Copy, my lord, has been served, my lord, upon my advocate on record by mail, my lord.
By?
By mail. By my lord email.
So for that you did not accept.
My lord, hard copy, my lord, be served, my lord, kept, my lord, tomorrow or day after need.
I think it has been sent by post also.
Post, my lord.
No, the client has taken it.
Post, my lord, yet to be received, my lord. Either by my client or my advocate on record.
I'll ensure that the copy goes. The copy could have given.
If not, give a copy.
Your lordship kindly keeps it day after. Tomorrow I am not there.
When this matter is taken up for hearing, the learned advocate for the caveator appears and submits that and seeks an accommodation on the ground that a copy of the civil revision application has been served only through electronic mail. First up, paragraph as paid for by the learned advocate for the
দেখেন সেটা গেছে রাখতে আচ্ছা ভালো কিন্তু 15 দিনে পাঠিয়েছে ঠিক আছে
This is for the transfer of the matter from Arambagh to Howrah.
Arambagh to Howrah, it's not far off.
I do understand, but my lord, the petitioner is staying with her aged mother and brothers are not
Not far off.
not paid, my lord. And nothing has been paid. And intentionally, my lord, may find, my lord, that he has been married on July 19th and she has been left to her paternal house on 25th of August 2020.
All right, file your written statement. It's not far off. You can file your written statement. You serve. I will consider thereafter.
Fine.
This application under section 24 of the Code of Civil Procedure is
No, my lord, I
maybe in
will.
difficulty.
No, my lord, I will.
Yes. None appears for the petitioner at the time of call. No accommodation.
I am the wife. Section 9 filed against me by the husband. I stay in
That's
Jalpai.
your husband.
No, my lord. My lord,
Why?
mental torture, my lord, that is, my lord, a separate issue. My lord, I stay in Jalpaiguri, Shiliguri, my lord, North Bengal. My lord, I have a 2 years son with me.
You are in service.
No, my lord, I am not in service. That is
Yes,
an
yes,
NGO.
kindly come to your
Yes, my
affidavit.
lord. Yes, that is an NGO, my lord. I will show, my lord, that is an NGO. Page number.
I asked you, you
31.
said no. Your
No, my lord,
affidavit
not in-
states that you are in
Yes, I am
service.
not service, my lord. That is a, my lord, he is a school, in a teacher, my lord, in a NGO. Page number 31 is the for the special child. That's an NGO, my lord. So, my lord, only difficulty is this. And 21st March is the next date before Maharashtra court for filing written statement.
This application under section 24 of the Code of Civil Procedure is at the instance of the wife paying for transfer of the matrimonial suit
This matter I am appearing for the defendant.
June, month list of June, end of
Appearing for
June.
the defendant petitioner, my lord, in this case, suit for declaration and permanent injunction. Suit in the year of 2017 for early disposal of the suit.
Early disposal
Yes.
of the suit.
Yes, my lord, that order 17 is allowed, and my lord.
What happened on 11th of December?
Order 11 rule 15 is the last chance, the last part of the order. Last part of the order. This
What is the miscase for?
case for suit for declaration and injunction.
What is the miscase for?
This case for my lord, the order, order my lord, the 11 order, my lord, 11 rule 15. That is the miscase. That is the an injunction is allowed. Order 16, order 670 or order 6 rule 17 is allowed. Amendment of plaint, my lord. And the kindly see the last part.
No. What is the miscase number 144 of 2024? What is it for?
My lord.
You have annexed the order sheet
Yes, my lord. I have
of
annexed
this
all
case. What is this miscase for? What is this miscase?
my lord, the I have annexed this written statement. I have annexed, but this case I have not annexed this petition. My lord, what is the miscase?
The order sheet is there.
Order sheet is there. My lord.
What is it for?
Application has not annexed. No. Yes, my lord, probably order 6 rule 17, my lord.
No.
My lord.
Order 6 rule 17 cannot be registered as a miscase.
Yes, that is the plaintiff defendant. It should supported by an affidavit. That is the my lord, the KLC page 35. That is the miscase 144.
35?
Yes, 144 of 2024.
Yes, what is it for?
It for plaintiff files a put up petition, put up allowed, plaintiff files a petition supported by an affidavit under order 39 rule 7 of the CPC of 151 today for hearing WO if any matter. That is the next page 36.
Under what provision this miscase was filed?
That is the file my plaintiff. I am in this case I am for the defendant.
Maybe, Mr. Mukherjee, but you have applied for expeditious hearing without ascertaining as to what is the miscase for, whether it has some relevance with this. It is to be considered.
Then my lord, I shall take instruction copy of the miscase.
When this matter is taken up for hearing, Mr. Mukherjee, learned advocate.
Also, my lord, the early disposal of the partition suit. In this matter, I am for the defendant and petition. Cameron Harvard, senior division, my lord, civil judge senior. That is the suit for.
You are for which defendant?
Defendant number 2.
Defendant number 2.
Yes.
Have you filed your written statement? When have you filed your written statement?
My lord, they have not annexed, my lord. I have only one of the plaint have been annexed. Has been annexed, my lord.
Yes. So, Mr. Mukherjee, you have not filed your written statement. It is yet to be accepted, and you have come for expeditious hearing. Your application for acceptance may be dismissed. Maybe dismissed.
Maybe dismissed. That's.
So, and you have come up for expeditious hearing.
I already,
And you have been asked to show cause.
yes, so cause, but without my
And you
lord
have come up for expeditious.
without appearing, my lord, this injunction is extended. I have
Mr.
already
Mr.
told to my
Mukherjee, that is a
junior,
different thing. That is a different thing. But your application for and the service return is also pending. All the defendants have not been served.
not been served.
Then how can a direction be passed?
22, 3 years have already passed.
Mr. Mukherjee, unless the suit is ready for hearing, all the defendants are served. Can the hearing proceed? No one knows what is the reason for
Whether alive or died or whatever it may or substitute.
So at this stage,
That's too much.
this application is at the
Expeditious hearing,
Yes,
my
Mr.
lord.
Rao.
I filed for the
Expeditious hearing of what?
partition, my lord, declaration and partition, my lord. We have filed the written objection, my lord. We have filed the written objection, my lord. And I am not being able to custard, my lord, as that is status quo is there, my lord. Injunction.
Ashun. You are the plaintiff.
My lord, I am for the defendant petition.
All defendants are coming for expeditious hearing. They are very
Time bound or
23 suit, Mr. Rao.
Lordship, my let's shoot for eviction, man.
Section 5 rejected.
Within time, this challan for passing challans, at least it is placed before the judge, the judge, repeated orders are being passed, kept with the record. Ultimate at the date of the hearing, it is said that you have not deposited anything. So 7-1 disallowed, 7-2 disallowed. I have annexed the entire order sheet, will kindly consider the ordering portion, the impugned order, third big paragraph, order dated 27th of January 2025. Last, the third big paragraph, fourth line.
First page.
First page.
Yes.
Further from the case record, it appears the defendant has appeared in
No. First page of the order dated 27th of
January.
Yes. Upon perusal of the case record.
Upon perusal of the case.
Yes.
Upon perusal of the, I am reading from fourth line,
Further from the case record. Yes.
Appears from that the defendant has appeared in the instant case such and such date, filed instance application on a 7th.
So that is within time.
Within time.
Yes.
Defendant has submitted challans of 2000 each towards house rent from the Bengali month of Falgun such and such, but did not pay a single money against such submitted challans or praise for passing of the said challan. Moreover, it is found that the defendant is liable to pay monthly rent from the month of Ashar such and such as per the provisions of provided under 7-1 of the Act up to the end of month previous to that, which is made payment with the interest of 10% per annum. My lord will now consider the order sheets, my lord.
Now, Mr. Shen, only one thing. Are you disputing the rate of rent?
No, my lord.
The period of default?
So period of default, my lord, that is disputed, but fact remains.
So if you have disputed, have you deposited any amount which according to you is admittedly due?
This is the challan, my lord, I have placed, my lord. Challan, my lord, peculiar case, my lord.
Where is that challan?
On page 25, my lord, order number 10. Like challans are mainly placed before the Sherestadar. Here the court keeps the challan. The last 3 lines, defendant also filed challans by way of list as per challan to be kept on record. This is the order date. Next, 11th order number 11, prayer for time to extension, prayer for filing written objection, 7-1 and 17-2 allowed. Thereafter, again, order number 12, here, the challans are submitted for passing the same. The court doesn't pass the challan even. I cannot deposit. In every, next, will come,
No, this is for every month.
I am
7-1C. In compliance with 7-1C.
7-1, the initial deposit also.
Initial deposit is 7-1A.
Yeah, A.
So thereafter, after appearance, you have to comply with 7-1C. And if there is any dispute, you have to deposit the admitted amount along with an application under 7-2.
Yeah, 7-1A and 7-1C, challans are deposited.
What happened to 7-2?
It has been rejected by the order impugned holding that.
No. With regard to the admitted amount, have you deposited that along with the challan?
Unless the
For that also challan was there.
Challan was
Show me your application under section 7-2.
That is, Malad will find at page 11, Page 1, the 10 is the application under 7-1 and page 11 is the application at 7-2.
What is 7-2A? 17-2A you are trying to incorporate in 7 also. Now, according to you, you have not admitted any amount to be due.
Right. I have current rent, I have been praying that the challans be passed. I am let me deposit the same.
Lordship, in a suit for eviction of licensee, I have made an application for addition of party. I am the co-sharer of the suit property. My case is that the licensee, the opposite party number 2 and 3 herein, Your Lordship, has already surrendered the suit property in my favor. I am in occupation of the suit property.
Maybe. So how are you affected with this?
Lordship, the suit has been for eviction of licensee.
That suit
The
will be
licensee-
dismissed. That suit will be dismissed. That is not against you.
Lordship, the thing is that I am in possession.
Maybe.
If there be any.
The plaintiff does not want to proceed against you.
Lordship.
How are you affected?
Now, I have annexed every document. Apart from that, I have also filed a partition suit.
What is the reasoning given by the learned trial judge?
At first, it has been stated that no documents has been placed by me. So I have.
So where is the order rejecting your application for addition of party?
Lordship. That is the last one is that on 31st January 2025. And prior to that, Your Lordships, on
You are challenging the order dated 27th of August.
27th of August as well as 31st January 2025.
What is 31st of January?
31st January 2025 is I have filed one recalling application.
Recalling was rejected.
By
Yes, give me a
annexing
minute.
all the
Give me a minute.
documents.
So the plaintiff claims that he was the licensee and you have elevated their status to tenancy and surrender. What is the dispute between the co-sharers?
I have filed also a partition suit.
Proceed with the suit for partition.
Lordship, I have filed and there is a status quo order is there also.
Where is the plaint of this suit?
Lordship, as that is at page 16.
This
I appear on behalf of the petitioners.
Yes.
I'm selling two orders. Order dated 10th of December 2024 and 12th of December 2024, passed in ESI case, tender case number 129 of 2024 before the Employers Insurance Court. The fact of the case is,
this is an order passed under section 45G.
the order passed under 45G which they have challenged.
Is under challenge. There is no provision of appeal in the statute
45G.
against such an order.
The provision, the dispute is the UCO bank cannot assail the ESI code.
That is a different thing altogether. Whether that order is an appellable order, an order passed under section 45G.
They could have filed a suit or alternatively filed with petition.
There is no provision of appeal. Have you checked up?
45 AA is provision.
The order passed under 45G is under challenge. Show me. There is no provision of appeal. Have you checked up?
Kindly mark, kindly excuse me. They cannot, yes, UCO Bank is not an employer of ESI. So they cannot avail under section 75. They file application under section 75. Now, if your lordship kindly take section 75 once.
Yes.
May I place it, lordship? Matters to be decided by Employees Insurance Court. 75(1)G is their application. One says
This application for temporary injunction was disposed of
on the same date without giving the ESI the opportunity. On the next day when the matter came up on 12th, kindly take the order. Page 77 of your lordship's brief. The first order is at page 74. UCO Bank has allowed debit transactions of the defaulter, which prompted ESI to issue order prohibiting his orders. It is under 45H. Now they were given 2 days of hearing. They did not turn up. The UCO Bank was given 2 days of hearing. That is at page 24 and 25 of your lordship's brief. Then 45G order was passed. Garnishee.
So the orders passed under 45G was stayed.
Stayed.
You serve Yes.
Lordship is asking me to serve within.
You serve by registered post will appear in the. Yes.
My lord, I am for the petitioner.
Yes.
My lord, kindly fix the matter tomorrow, as there is a eviction suit is pending in the Civil Judge Junior Division Chandannagar Court. The conducting advocate is ill. My lord, praying for a stay order in the lower court. Look, there is a contempt which has been filed before before Honorable Justice Shampa Sarkar. Then
What is the order under challenge?
My lord, the order which is under challenge is that on 29/1/2025, there has been an appeal preferred against against this order, against the lower court order. There has been an appeal, and my lord, commission has also been.
How are you aggrieved by this? The defendant's evidence has been closed. They said that they do not want to adduce any further evidence. So it has been fixed for argument. How are you prejudiced by this? Madam, the defendant's evidence, they could have been prejudiced. You are not affected by this. Kindly come to the impugned order 29th of January 2025.
My lord, they did not pay rupees 5,000 also, which is
So their evidence has been closed. How are you affected? If they choose not to appear, not to adduce further evidence.
My lord, kindly fix the matter for tomorrow.
The learned advocate appealing for the petition. Yes, call the next matter.
I have taken instruction. This is expeditious disposal of injunction application.
What instructions you have taken?
One Mr. Priyoranjan Vishwas is appearing for the plaintiff.
Do I have any difficulty or?
No.
All right. This application under Article 227 of the Constitution of India.
I am the plaintiff in a suit for specific performance. Lord, I was seeking
the caveator.
Yes.
Yes.
And the impugned order is Lord by the impugned order, Lord, the learned judge Lord allowed an application for amendment of Lord the written statement. In 2004, there was an agreement. But in 2004,
amendment of the written statement has been allowed.
Allowed. The nature of the amendment
come up.
Against that I have come up because Lord, I say this is an unnecessary amendment. Why they say? Your Lordship will kindly have a look at
the trial commenced.
Yes. 2014 it has commenced.
After that,
I have put in Lord the deficit Lord. But your Lordship will
to make his submissions.
Kindly have a look at Lord their application Lord page 81.
Yes. What is the suit for?
Lord, a specific performance suit. In respect of a property, Lord. Lord, the paragraph 2, that during the pendency of the suit, some vital facts have been developed due to changed circumstances and the said facts are required to be inserted in the written statement by way of amendment for proper adjudication of the dispute raised in the suit. Otherwise, the petitioner will suffer irreparable loss and injury. Paragraph 2 ends there. Then the schedule of amendment at page 82.
So according to you, the proviso has not been, no explanation with regard to the proviso.
So that is one. Secondly, Lord, that the trial has started. Thirdly,
Yes, for
more
that
importantly,
proviso explanation has to be there.
Lordship. More importantly, Lord, your Lordship will kindly see the text of the amendment, Lord, whether it is necessary for the purpose of determination of the suit or not. They say that because of the pendency of Lord, the suit, which crossed Lord 19 years, the property value has increased. The agreed value at that point of time was 30 lakhs in 2004. They say that we have taken out a valuation statement. Now the property is valued about 9 crores. That is a relevant fact which according to them has to be incorporated in the written statement. Now, Lord, to which my answer is, Lord, whether your Lordship will allow Lord an unnecessary amendment or not, which has got no
there are
material
decisions which says that if the valuation of the property has increased in the meantime.
But that is a
So
Supreme Court which says that one of the judgment that is
either way. One judgment is that because this is a discretionary relief.
But for that, Lord, the written statement need not be Lord amended.
If
It
the
is not for the
valuation
court
comes,
because Lord, your Lordship.
valuation comes, Mr. Mukherjee, that may be a relevant fact because what has to be how it has increased. Because those line of decisions, Mr. Mukherjee will be finding the court at that stage considered. So if it is on evidence, you may be getting a chance to say, no, it's not 9 crores. They are saying 9 crores.
Yes.
So it's not 9 crores, it's 90 lakhs. You may say so. So you may also lead evidence to that. But because there are some decisions which says it's a discretionary relief. If you are entitled to, if you are willing to pay that, yes, then this decree for specific performance will be granted. Some decisions are there.
I will just not.
Yes, you are absolutely right. Some decisions are contrary to that.
Lordship.
So that can be taken care of at the time of.
But all that I say before your Lordship, Lord, that whether Lord, the pleading is necessary to that effect about Lord, the incremental price of a property, which is the subject matter
That
of
is
a
a relevant fact for the exercise of discretion.
Then,
by
Lord,
the court.
after 2 or 3 years, if there is an increment to the valuation of the property, Lord, they will go Lord, amending the written statement. Now that Lord, your Lordship will kindly see, Lord,
So
if
it's
the
90
court finds.
You have said 19 years. So it's a substantial change. From
But they could have, Lord, in
no, not
2014, 2014,
90.
Lord, the evidence had started. Today we are in 2025.
Whose
Lord, the
evidence has
passage
started?
of time.
Whose evidence has started?
Our Lord, the plaintiff's chief.
Not closed.
No, close হয়নি বলো। No, সেটা তো আমি জানি, সেটা আমি জানি।
Sir, please take your seat.
No, it is not closed. It's not closed.
Mr. Mukherjee, kindly consider this. If this is brought, I fully appreciate because this might not be, because considering those line of decisions, you may get a chance to prove, no, the valuation has not increased to the extent of 9 crores, it may be 90 lakhs.
But I would have understood if they were not saying that, no, if you pay me this amount, I will be executing the deed to give a quietus to the suit. But they say that there is no agreement at all and they're denying the agreement. Yet, on the other hand, they come and say that, no, the valuation is this.
It's an alternative plea. Mr. Mukherjee, that can be always taken in the pleadings.
But
alternative plea for the
bloody.
purpose of which may be relevant.
But there's no counterclaim by them.
No,
to say that if you pay me this amount.
No, not a question of counterclaim. An alternative plea which may be relevant for the purpose of exercising the discretion by the court at the time of final passing of the final order.
But Lordship will kindly see the text that they are trying to incorporate. Lord, whether Lord they are Lord just blowing hot and cold. Lord, paragraph 24 at page 82.
Yes.
That the alleged invalid agreement for sale was executed in the year 2004. And at that material point of time, the value of the property was fixed at rupees 30 lakhs. Only but the plaintiff, without any reason, intentionally and deliberately delayed to execute the said deed, and as a result, the agreement for sale has been cancelled in appropriate time, and in the meantime, the valuation of the property has also increased. In the year 2004, the value of the property was 30 lakhs. And in due course, 19 years already passed, and at present, the market value of the property already reached 9 crores and odd. And the defendant craves leave to file valuation report obtained from the registration office. And the plaintiff now has been trying to take advantage of purchasing such valuable property at a minimum rate of rupees 30 lakhs.
This is
only
by
by paying
take advantage, Mr. Mukherjee, of
and
those
they say
line
it
of.
was,
those line of decisions.
But that is not a discretion vested on the court to
Yes.
say that at the time, if you grant a degree of specific
Material
purpose,
is available to enable the court to exercise that discretion in a more judicious way.
but my lord, until unless the court, my lord, is minded to pass a decree, my lord, that exercise at this stage on the basis of, my lord, a contrary pleading which says that the agreement has been cancelled. That is their pleading, the last two lines.
Yes, yes.
And now yet they
So
say
that
that
is-
no,
that
the
is their
valuation is
defense.
9 crore.
That is their defense. If the court finds no, you are entitled to a decree for specific performance. It may not be at 30 lakhs.
But that is the discretion of the court, my lord,
Discretion of the
according to
court.
the specific
So that
pleading.
discretion, Mr. Mukherjee, that is considering the market value. Those line of decisions you will be finding, some value has been fixed, and mostly that is by the Honorable Supreme Court.
But that was a my lord, one of the judgment, my lord, which says that if there is a my lord, long passage of time, the court
Here
grants,
also
my lord,
it's
the degree, the court might, my lord, consider offering some compensatory, my lord, amount,
Yes.
my lord, not considering, my lord, the agreed amount.
Yes, not the agreed amount, considering the passage of time and the valuation of the property has increased. So that discretion is always left with the court. If some basis is there in the pleadings as well as in the evidence, if it comes in the pleadings, they have to adduce evidence in support of that. You will also have to be given an opportunity to controvert that, or
revert, my lord, the valuation that they have, my lord,
yes.
come up with.
So you may also say, no, it's not 9 crores, it's 9 lakhs or 90 lakhs, 30 lakhs. So it's maybe 90 lakhs or 40 lakhs, whatever it might be. So those evidence will come even if the court is minded to grant a decree for specific performance.
Whether, my lord, in a specific performance suit at the time of argument, my lord, this may be a
This is an
judgment.
innovative way.
But that is,
This
my lord,
is
I say that
innovative
no, it
way.
is 9 lakhs or they say it is 9 crores and my lord, we.
May not be relevant because the court will be only deciding on the agreement, which is there whether to
Readiness,
grant.
willingness and the existence
Yes.
of the agreement.
Yes, but the fact is long passage of time. Here also 19 years from the date of the agreement. So it will take some more years also to get the, let us assume one year, or by this year, end of this year, let us expect that the suit will be disposed of. So if this comes, how you will be prejudiced?
But the prejudice is, my lord, I am saying that this is an unnecessary, my lord, amendment. It has got no nexus with, my lord, the
What is
object
the
of the
finding
suit.
of the learned trial
But
judge?
there is no finding. My lord, your lordship will kindly come to the one-page order. But kindly, my lord, come to, my lord, the paragraph starting from it appears from the case record
Yes, I am at that.
that the suit trial has already been commenced. It is further appears from the petition filed by the defendant that the defendant has prayed for amendment of WS regarding some development took place during the pendency of this suit. It further appears from the materials on record that the proposed amendment is formal in nature and will not change the nature and character of the suit if allowed. Moreover, as the plaintiff will get the opportunity to file subsequent pleading rejoinder regarding this amendment, and as this is not a principle, my lord, which because my lord, all
and character, you are on that.
no,
whether this
nature and
is-
character, it is not changing.
So you are on really on that whether it is necessary for the
Yes,
purpose of
yes.
deciding.
Yes,
But
that
the
is,
fact that
and there is no, my lord, an iota of, my lord, a statement in the application to say why it is belated. Because they admittedly
they
say
are
that
saying-
they had started.
they
my
are
lord,
saying that by passage of time they are trying to take today's valuation because the suit is at the evidence stage. In close proximity, the suit might be disposed of one way or the other. So this is the current valuation which they now seek, taking aid of those
that will,
decisions.
my lord,
How
impact
you will be
my-
affected? Because perhaps you may not need to amend your pleadings for this. You may only, because because for amendment of the written statement, you are not required to amend your plaint. You can, in your evidence, since your evidence is still now going, you can lead contrary evidence in the disregarding or contrary to this.
But in my respectful submission, your lordship will
Have you
consider.
got those line of decisions where this Supreme Court have?
Yes, your lordship
got
will.
those- Ca- Mostly those are of the decisions of the Honorable Supreme Court.
One of the
Have you
Supreme Court,
got
I used that, my lord, before, my lord, the division bench of Justice Shomenchen in one of the matters.
Yes.
But I'll giving
I
your
think
lordship.
that will be better because our Supreme Court may enhance that in exercise of those powers. 142 that may be. So, no, এটা না, এরপরে আরেকটা আছে। এরপরে আরেকটা আছে। আরো later judgment আছে। 2 p.m. as your lordship pleases. Because kindly think over this.
I'll
because
get that judge.
get those judgment, and this is only I think you will not be prejudiced. Maybe that I accept that this may not be a relevant fact for the purpose of deciding whether you are entitled to, but that may be relevant for the purpose of exercising the discretion whether you are entitled to this degree of specific performance on 30 lakhs or at some enhanced value. Considering the passage, it's not in dispute that there has been a passage of time of 19 years and the market value of the property has increased. Maybe the court may find that you are not responsible for the delay, they are responsible for the delay. The court may ultimately hold no, you may be entitled to a decree at the original price. But in case the court is of the view no, some enhanced amount, this may be a relevant fact because the evidence he will be producing some evidence, you will be also producing some evidence to the contrary.
Lordship.
So it will help the court in exercising the discretion.
Lordship.
Kindly consider in that.
Lordship. I'll.
Huh?
3 p.m. But maybe at 3 p.m.
3 p.m. There is no 3:30.
I don't. No, Lord.
আছে কিছু আজকে 3 p.m. নেই. How much time you will take?
Not much. 5 minutes. I'll just not rely upon the judgment.
My lord, I'll only rely upon 3 judgments, my lord. Suppose that the proviso will not apply over stricto sensu. And my lord,
Though Mr. Mukherjee has scarcely referred to proviso, I think he is not very much relying on the proviso. That may be one of the.
We say, my lord, that the proviso, my lord, they have not, my lord, satisfied the proviso.
Yes.
Well, nothing they have said.
Case of written statement.
How much time it will take?
Not more than 10 to 15 minutes.
4 p.m. Mr. Mukherjee?
Lordship. Lordship.
4টের সময় না।
I'm grateful.
4টের সময় আছে? Then Mr. Mukherjee come at 3:30. I'm told that some matters are fixed at 4.
Lordship. কি বললি?
Judgment.
Matter number 1 for judgment.
For all the reasons as aforesaid, the writ petition stands allowed. Yes, call the next matter.
Judgment was called.
Writ petition stands allowed. We'll be getting in the server.
Can I see the order? Can I see the order?
After it is uploaded in the server. We'll
Writ
get it
petition is
today.
allowed. Writ petition is allowed.
Yes. Yes.
This revisional application.
Please use the microphone. Yes.
This revisional application was filed by me, the judgment debtor, of the initial suit. The initial suit was filed for declaration and mandatory injunction. After the order was passed, the execution case was filed by them, by the decree holder. But in the execution case, prior portion was a little bit changed. It was changed to an extent which has itself changed the entire factual matrix of the case.
What was the decree? Show me that decree.
Lordship. Lordship, in page 10 of the revisional application,
Page 10.
Lordship.
Yes, page 10.
Lordship, the entire story of the case has been written. The vital
Show me the
portion.
decretal portion.
Lordship.
I'm not deciding this. An appeal against this. So
Kindly come
now
to
it's at
page,
the
page
execution.
20. Your Lordship.
20, yes.
Lordship, at the bottom portion of the 19, the ordered portion comes. That the instant suit be, and the same is decreed in favor of the plaintiff on contest against the defendant number 1. It is declared that the plaintiff has right, title, interest, and possession in respect to the suit property. The defendants are directed to remove their belongings, that is bamboo poles, from the scheduled suit property within 60 days from the date of passing of this order and judgment. Else, the plaintiff would be at liberty to apply for its execution. Now, Lordship, what has happened? Kindly allow me to put forth the fact of this case. 2 minutes time I will take.
Not the fact. What happened? What is the application in the execution?
Yes, Your Lordship.
What is your grievance?
There was no prayer in the recovery, prayer of recovery in the main plaint. That was
not granted also.
That because the fact taken was the property was already in possession of them. That was the situation. That was the question. That was the fact placed before the trial court. Now, Your Lordship kindly comes to the.
What is the impugned order?
Lordship, impugned order is we challenge the maintainability of the execution case.
Yes, where is the execution petition?
Lordship, execution petition at the time of filing this case, it was not in our hand, but before on the last occasion when the order was passed, stay order was passed in my favor, I submitted this before the court. Lordship kindly comes to the point number 11. Since the moot question was in whose possession the land is, the plaint was filed, then the stand taken by them was it is in their possession. After this, in the garb of execution, they have filed a rectification. Then they thought that yes, there is an error that we have not filed recovery of possession, etc. in the prayer. They changed their mind and they started urging the court that kindly allow us to recover the possession. In the garb of execution, they did it. Against which I filed the maintainability petition that this execution itself is not maintainable. Some decree was passed to in favor of them to do something. Thereafter, the change in the execution that no, the land is not in my possession, kindly allow us to take the possession.
So according to you, the order only directed you to remove the belongings, that is bamboo posts, from the scheduled property.
Lordship, it was in their prior mandatory injunction, in which I failed. I have preferred an appeal because I have changed the maintainability itself. Because your Lordship will appreciate this point that a declaratory suit wherein recovery of possession has not been paid.
Have you removed your belongings?
No, your Lordship. I could not, your Lordship, because of some personal reason. My 23-year-old daughter has suddenly died in the month of December for 3 days of fever. After 3 days of fever, she had suddenly died. My family position was also not very okay. My emotional setup was also changed. Those are separate issues, your Lordship. I'm not pressing this because those are not legal points, your Lordship.
So now you are ready to remove your belongings?
Lordship, so far as because land is in my possession since 35 years, I am doing decorating business from there.
That is one thing. When can you remove these bamboo poles?
Actually, bamboo poles, little bit of bamboo poles are there because your Lordship.
When can you remove that?
Lordship, that I have to take instruction from my client.
Not instructions, you remove the bamboo poles. So the police will not go there, bailiff will not go there.
Kindly says this 11, point number 11. It is written there. That
Yes, I've seen that. I've seen that. Remove the bamboo poles. How soon can you remove the bamboo poles? No one will go there. You remove the bamboo poles. When can you remove the bamboo poles? No one will go there. Bailiff will not go there. Police will also not go there.
what about my rest of my possessions? Rest of my.
That will be, remove the bamboo poles first. Remove the bamboo poles. When can you remove? Because that decree is there. You are not aggrieved by that. So remove the bamboo poles. When can you remove the bamboo poles?
Lordship, by now I have put again few bamboo poles because there was.
You have to remove that.
I will do
that. When
Lordship,
can you remove that?
There were 700 bamboo poles and most of them they have set fire in it and it all are burned.
So if one is there, remove that.
Yes.
If 1 or 2 is there, remove that. When can you remove that?
Kindly allow me at least 1.5 months time because my lord, my family position is also
1.5 months time cannot be granted to you. Then the bailiff will go and remove.
Lordship, if the execution case itself does not stand.
That I will clarify. That I will hold. If you are willing to remove the bamboo poles, I can give you time.
Lordship, I will, your Lordship.
Not 1.5 months.
But your Lordship, not the rest of my...
Not 1.5 months.
Not the... Kindly assure that the rest of the table chairs are also there.
That will be considered with all belongings.
Yes, no, your Lordship, it was there. Possession is with me.
Bamboo poles was there.
Only bamboo poles was there.
Yes.
But your Lordship kindly sees in 11, it has been changed. All the belongings had been added.
You comply with this decree?
Lordship, only
bamboo can you comply with this decree?
Lordship, at least 1 month time I need. Because there are 300 bamboo poles still lying there.
1 month time, whether it can be granted or not, I will consider. Yes.
Lordship, only bamboo poles, 1 month time will suffice. But rest of the things, possession is with me and appeal is still under consideration.
Appeal may be under consideration, but have you obtained any order of stay?
Lordship, judge is not there, your Lordship.
That is neither here nor there. So mere filing of an appeal does not amount to
Lordship, I
operation.
understand, but till
Does not amount to
9th
stay.
APJ is not there, your Lordship. Lordship, kindly give me at least 1.5 months time so that I can arrange for the put up and arrange for all other appeal hearing also.
That is, if you can remove your bamboo posts within a short time, I will allow you. Not 1.5 months.
Lordship, short time means at least 1 month's time because the 300 bamboos are also there.
300 bamboos.
Yes, your Lordship.
Then I will appoint a person who will remove that within 2 days.
Lordship,
You
what
need not
about
take the trouble of removing that.
Lordship?
You
What
need not
about
take the
the
trouble.
rest of my belongings? Because the land
need
is
not-
in possession.
Madam, you need not take the trouble. For you, it will take 1.5 months. Let us see whether anyone can remove that within a short time. Within the shortest possible time, if you remove, yes. Otherwise, we have to find out an alternative who can remove that in a shortest possible time.
Lordship, this means that the execution is being allowed.
Execution of the decree, nothing more than that. Nothing more than that.
So your Lordship,
Execution of the decree.
This execution petition, this 27 is being modified.
No. I will not allow modification as it stands. Decree as it stands. Decree as it stands.
Okay, then 1 month time. 1 month, it is.
All right. So let me see if it can be done earlier. If it is done earlier, it can be. I was giving you time to be reasonable so that you can remove. That is.
Lordship, without instruction, all of a sudden, kindly give me 1 day time so that I can take instruction. How long it will take?
1 day time. Yes, madam, but be reasonable.
Lordship,
Come with a reasonable time.
Lordship, what
Then-
is the, I mean, what is the, it is not precise, your Lordship, reasonableness. I don't know what is the exact time.
Reasonable, you know your client also knows the reasonable time.
Lordship, 10 days, 15 days, I don't know. Let kindly allow me to take instruction from him.
Yes. Let her come tomorrow with instruction.
It is taken up tomorrow. I have no objection.
Tomorrow.
I am moving. So therefore, I am less.
Tomorrow in the
Lordship,
morning.
Tomorrow in the morning.
After some argument, the learned advocate appearing for the petitioner. What is the reasonable time you want? If they remove within some reasonable time, do you have any objection with regard to that?
Yeah, but after the resistance,
That is why if they on their own, if they on their own remove that, do you need police even then?
but we have deposited the police.
Relief is also not necessary.
Your Lordship approach is quite different.
Lordship, only regarding the bamboo poles concerned.
Relief police thought money deposit.
Now they will let them take instructions whether they can on their own. Nobody will be involved.
That is the way
Lordship-
your Lordship is decreeing in 1968. Your Lordship knows. No police.
Lordship, police will help us required for recovery of khas possession. It was written.
No, I'm not on khas position. Remove the bamboo post.
Yes, your
What is there in the decree? So that can be done within the shortest possible time.
I will try, your Lordship.
Item number 6.
Yes, then let a rule be issued. Sir, how many times you will submit this? How long it will be pending before the Commissioner of School Education? How soon it will be disposed of by the Commissioner of School Education?
This is not your lordship's order. Your lordship's order is that after hearing the DSC and the other party, we will pass a reasonable order. Now, this order was passed without giving any notice to the DSC. That's why you also granted time to hear appraise after giving.
Where is Mr. Boisho? This matter was fixed at 2 p.m. Initially, it was taken. He was not present. And this was the order which was placed. I took note of that. And thereafter, Mr. Boisho took time.
Yes.
And you are again placing that order.
Let the rule be issued. Otherwise,
Tomorrow, not today. Tomorrow, no 1 week time. Tomorrow, if you do not appear, rule will be issued with that understanding. Yes. If you do not comply with the order, rule will be issued. I do not know before whom it is pending. Yes, call the next matter. ওখানে একটা order record করুন. An accommodation has been paid for on the ground of Mr.
I beg to appear for the petitioner, my lord, this matter.
Yes.
Lord, I had taken out an application. This is a suit of 2012, your lordship. And I was the performer defendant in the matter. No summons were served upon me, though the copy shows that there is a service. I am a company without any seal someone has taken. When I came to know of the matter, I filed an application seeking relief under Order 14, Rule 2 of the CPC, my lord, that the suit is barred by limitation and the plaintiff, he does not have a locus standi to file this particular suit. The property has been...
Locus standi point, can it be decided as a preliminary issue?
But insofar as the limitation is concerned, after 17 years...
Limitation also, if it is a mixed question of law and fact, it cannot be decided as a preliminary issue. So I think that issue has been framed. Any issue has been framed that the suit is barred.
The suit is at the stage of closure of the evidence.
Then, Mr. Jha, why are you on this? So the issue...
The thing is, now, one thing has been...
The issue with regard to the suit is barred by the limitation has been framed.
It has been framed.
So that will be decided along with the...
I'm suffering because it's my property which is being put into the... This is subject matter of the list, my lord.
The evidence has been... It's on the verge of conclusion of the evidence.
Insofar as... Kindly bears for a moment, my lord. Insofar as the suit is concerned, this will drag on the issue that certain documents have been sent to the Department of Questionnaire and those documents will never ever come up.
Mr. Jha, the only difficulty is that limitation is a mixed question of law and fact.
My lord.
Can it be decided as a preliminary issue?
But that's the discretion of the court considering the facts.
Cannot be. If it is a mixed question of law and fact, cannot be decided as a preliminary issue.
I understand what is calling from your lordship. Then your lordship gives a specific time frame within which the matter should be, the suit should be disposed of.
What is the reasoning given by the learned trial judge?
I beg your pardon, my lord.
What is the reasoning given by the learned trial judge?
He says about the delay. I have come here after 11 years and that's the reason. In the second page of the certified copy, your lordship will find second paragraph. Therefore, considering the situation when almost all the matter pertaining to the suit, including the evidence, is going to be closed at this stage, whatever prayer has been made by the performer defendant number 5 regarding maintainability of the suit is not proper and is devoid of merits, and accordingly the application...
Where is the maintainability application?
My lord?
Where is your application?
My lord. My application is at page...
For framing a preliminary issue.
My lord. That is at page... starts from page 23, your lordship. The put up petition and page 24.
Page 24.
My lord. In paragraphs 5 and 6, your lordship, I have In six,
the
I have
ground of
categorically written.
locus standi and on the ground that it is barred by the laws of limitation.
Because it's a categorical averment in the plaint that in 1995 he has left the premises. And in 2012 he comes up and files a suit, and the averment that he left the premises in 95 is inherent in the plaint itself. Your Lordship considers the plaint, which is at page, starts from page 15, Your Lordship. Your Lordship comes to page 18, Your Lordship kindly takes up page 18, that is the plaint. Paragraph 8.
Page?
Page 18, Your Lordship. This is the plaint. Averment of the plaintiff in paragraph 8. That the plaintiff states that in or about 1995, due to poor financial condition, the plaintiff had to shift his residence to such and such place, and as such could not pursue the matter with the defendant number 1. So 95, he leaves the suit premises. He files the suit in 2012 after 17 years. And my property is put to litigation and I'm suffering.
There is an injunction.
No, Your Lordship, there is no injunction. My Lord, I am not suffering. I'm a developer. I'm not able to deal with those properties.
This application under Article 227 of the Constitution of India is at the instance of the defendant.
Performer defendant number 5.
The instance of the 5th defendant who has been in Any unnecessary adjournments? Yes, next.
Obliged, Your Lordship.
36. 36, I am for the decree holder petitioner before your lordship. In this case, appeal has been filed by the judgment debtor. Section 5, on the day of allowing the Section 5 application, the stay has been given without considering the current valuation of the property. I am only seeking before your lordship, lordship will kindly.
For the you are for the
decree holder, respondent
That is
petition.
why respondent in the title appeal.
Yes,
You
absolutely.
want enhancement of the occupation
Enhancement, but that was considered by the learned court, but with his own assessment. Lordship will kindly seize.
What is the extent of the
500 square feet?
500 square feet, 5,000, Mr. No. 10 rupees per square feet.
Another point is that, from the date of the decree.
I'm expediting the hearing of the
Expediting, but in the light of Atmanam and understand why. Yes, Lordship will kindly.
Then your appeal will be stayed, Mr.
Yes, I
You want that?
I know. I bow down. Only on the
So I'm directing the appeal to be expedited. You have got this 5,000.
No, the problem is Lordship will kindly see the date of the last portion of the order. There be an order of stay of the operation of the further proceeding, subject to deposit of 5,000 only per month as occupational charges with the learned court positively within first 7 days of the following month. This order has been passed not from the date of the decree. That is also a point I am taking before your lordship. And this order, this judgment was passed. Lordship will kindly see that
What is the stage of the appeal is otherwise ready for hearing.
Section 5 on that day. This
Mr. Chattopadhyay, are you willing to get more occupation charges, or you want property? You want the property or the occupation charges?
What has fallen from your lordship?
It appears that you do not want the property.
I want the property, but at the same time,
I'm expediting the appeal. You are not confident in the appeal. It shows you are not confident in the appeal. This shows you are not confident in the appeal.
5th September 2023, judgment was
Premises
passed.
Tenancy Act.
No, it's only for eviction of licensing.
Licenses. So I'm directing the appeal.
Only that. That lordship will kindly clarify that. 1 year's rent, occupation charges I will get. That is the only point I'm harping before your lordship. I'm not on that valuation report and anything. Lordship will kindly see in the top of the order, this last portion. On perusal of the record, it appears that instant appeal has been preferred, challenging the operation of the judgment and decree dated 5th September 2023. And this order was passed on 2024. But 2024, at the date of my lord, yes, it passed on 6th August 2024.
When did you file the execution case?
Execution case prior. Yes.
When?
Yes.
They have contested the execution case.
Yes, title suit 2003, execution is 66 of 2023. Impugn page 2, internal page 2, second paragraph.
So you are not agreed with the quantum.
Quantum, if your lordship, it takes time, I bow down on that part. But if your lordship
take time either way.
Clarifies that, that it has to be paid from the date of the decree. That
cannot be clarified in the absence of the other side, Mr. Chattopadhyay.
That I know.
Then the appeal has to be stayed.
Then both ways your lordship is then I will have difficulty.
That is why.
One thing may I pray before lordship, I'll serve and come. Lordship fixes the next week time. In that case, this is serious.
Service contested.
Lordship.
Service contested.
This is on the face.
Maybe
lordship, this
everything
is on the
face, Mr. Admission, everything is on the face. On the prima facie, something. That is why admission.
At least let that be paid from the date of the
Mr. Chattopadhyay, learned advocate, appearing for
my application. Well, the petitioner's predecessor filed, being Nonilal Banerjee, filed an suit for partition in the year 1976. This suit was decreed in the year 1983. Partition decree was, I have annexed the partition decree, and the decree was put in execution. The final decree was, petition was filed in the year 1984. Thereafter, that was continued till the Nonilal Banerjee was alive. But after demise of the Nonilal Banerjee, the present petitioner came into the picture.
What is the awaiting orders from the Lani district judge? What is the order?
This is the thing. This is, I'm coming, my lord, within 2 minutes. My lord, since
What is the order awaiting orders from the district judge?
my lord, awaiting order is that, my lord, I filed, when I came to the picture, I tried to, wanted to proceed with the execution. My lord, the original record of the shoot was traced out, but the execution record was not traced out. I filed a reconstruction application, my lord, accordingly, I filed an application with the Lani decision on 11th April 2023. But nothing happened. Thereafter, I filed a reconstruction application on 16/10/2023 that was kept pending. I obtained an order from the.
What happened on 21st of February?
Uh, 24.
21st of February 2025, last order.
Last order. Well, nothing. Again, 26 March has been fixed for awaiting order. But this is the thing. Well, impugned order. Well, there was an order of the Honorable Court to dispose of only two lines. Honorable Justice Shampar Sarkar directed to dispose of this reconstruction application within 1 month. Order was communicated accordingly.
Now the records have been traced out.
Record has been traced out. The Lanit court below, Lanit court below, executing court in the impugned order has found that record has been traced out.
And reconstruction, it's feasible to reconstruct
yes.
the records.
Again, Malad has been sent to the Lanit district judge for this order. Malad, there is an order of the Honorable Court to disposal the reconstruction application in 1 month. Lanit court below is not doing that. Again, Malad, when Lanit district judge called for the report has been sent. Lanit district judge now has nothing to do over here. Malad, my execution proceeding is being stayed in this way. But date after date is being fixed for awaiting order for the High Court from the Lanit district judge. But district judge called for the report. Report has been said. That is district judge chapter has been closed. Now they have to comply with the order of this Honorable Court. Honorable Justice Shampar Sarkar directed to dispose of this reconstruction application within 1 month. This is not
that order.
Malad?
Where is that order?
Malad,
You have not annexed that.
that I think. Honorable Justice Shampar Sarkar has been pleased to direct that running base 2 independently to dispose of this application, strictly in accordance with law. It is not being complied with. I pray before your lordship for modification only this portion, nothing else. I have no objection regarding the rest portion of the impugned order. Only this portion, for this portion I have come before this Honorable Court. Let this reconstruction application be disposed of, my lord.
The learned advocate appearing for the petitioner submits that in spite of a specific direction passed by a coordinate bench in CO number 672 of 2024 on 12th of March 2024, Call the next matter. Communicate করিয়ে দেবেন, এগুলো নোট রাখবেন। Yes.
One of the petition. Malad, this is an eviction suit. Malad, matter malad two grounds. Malad, the defaulter as well as malad the reasonable requirement. Malad, as per the plaint, malad, I am not at all a defaulter because malad their admitted case up to April, malad petitioners paying.
Why you filed section 5 application?
Section 5, malad 7.1 and 7.2. Malad, this if malad I do not file, malad I deposited the rent after 2018, since 2018. Malad, since 2 years, malad the 16th, malad the suit was filed. Malad 16/2000 suit was filed. Malad only 2018 I am paying rent. But 2 years, but malad it is not a defaulter because malad April, kindly see malad the plaint. Malad,
If you are not a defaulter, you need not pay. If you are not a defaulter, you need not be worried.
But kindly see malad the plaint. Malad kindly see page malad 22.
How we will get over the judgments of the Honorable Supreme Court?
But
For 2 years, 1 year, section
but
5.
if malad 3 grounds, malad if malad this did not allow miscarriage of justice, malad he is not at all a defaulter as per plaint.
Challenge this order to the
Kindly see, malad this is our High Court judgment. Malad, after considering the Supreme Court judgment, malad and also landed judge consider this. Malad, paragraph 22.
22 and 23.
Taking into consideration section 40 of the Premises Tenancy Act.
Premises Tenancy Act.
Sir, you are consciously citing this decision. I'm asking you.
But only miscarriage of justice.
I'm asking you, you are consciously citing this decision.
If you are not, well, only with the landed judge, kindly see the order.
I am asking you, are you consciously citing this decision? Where are the division bench judgments?
Single bench.
I think in this judgment it was said that section 40 of the Limitation Act was not considered in Vijay Kumar Singh versus Amit Kumar Kamaria.
This judgment was considered by the learned. Kindly see the impugned judgment.
Sir, don't allow me to. Sir, it has been hailed by the Honorable Supreme Court. Section 5 is not maintainable. Even then, you are relying upon a coordinate bench decision. Division bench has held so. It was referred to a division bench. Even then, I am asking you, you are consciously citing this decision. And considering all those decisions, I have delivered 2 judgments. Where are those? You have not brought those. Considering the effect of section 40 of the West Bengal Premises Tenancy Act.
Then I am paying adjournment. Kindly see, kindly.
You have done a research work, you have brought one judgment.
Kindly see this judgment. Or impugn order.
Yes, yes.
Impugn order says.
Yes, Vijay Singh was considered. So after Vijay Singh was considered,
the 3 aspects. Firstly, where the appear defendant is fixed summons such as. Secondly, where the defendant is unable to appear on the date. Thirdly, where the opinion of the court refusal of condemnation will result in miscarriage of justice. In this case, admitted the April within 8 months the suit was filed.
Sir, it has been held section 5 is not maintainable. In connection with 7.1, it is not maintainable. Reason is,
yes,
you know all these, even then you are citing this. This application under Article 227 of the Constitution of India is at the instance of the defendant and is directed against an order dated 4th of December 2024 passed by the learned civil judge, Junior Division, 2nd Court, Barakpur, District 24, Pogonas North, in ejectment suit number 79 of 2015. So by the order impugned, the application under Section 5 of the Limitation Act filed in connection with Yes, Mr. Mitra.
This application, my lord, immediately after filing the order under challenge is of 7. By the order impugned, my lord, the learned judge.
Which is the order under challenge? 10th January.
10th January.
7-2 rejected.
7-2 rejected since the application on the date of filing of the revision, my lord, enter appearance, I have filed 3 applications. One under section 7-1, another 7-2, disputing the area rents. And my lord, that was, my lord, directed to appear, my lord, for hearing. And along with that, my lord, I have filed an application, my lord, under Order 7, Rule 14, directing the plaintiff to submit document in order to enable me to file written statement. That application has been kept pending, my lord. The 7-2 was fixed for hearing, and on that date, my lord, the court directed that since I have not filed written statement, therefore my applications under section 77-2 consequently rejected.
It was filed within time.
Within time. My lord, order number 2, kindly look into.
You have annexed the order number 2.
Yes, my lord. First order, there was a direction for appearance on order number 17th October 2020. Defendant.
Along with a challan of rupees 5,000.
5,000. That was also deposited.
By the order impugned. Yes, Mr. Alda.
Defendant is a petitioner before your lordship.
Yes.
My lord, this is a suit for recovery of money. My lord, in the said suit, my lord, the plaintiff categorically admitted that my lord, he received rupees 17 lakhs from the defendant. Now, by way of proposed amendment, he want to withdraw his admission, my lord, made in the plaint, stating that my lord, he received only 10 lakhs. My lord, kindly state why, my lord, come to the plaint case at page 11. Paragraph number 9, my lord. In the middle portion, my lord, that said Sujoy Ganguly, have you also got it?
Yes.
Said Sujoy Ganguly handed over 2 AC account pay checks in favor of the present plaintiff, check number such and such, dated such and such, my lord, 5 lakhs drawn on Indian Overseas Bank, Fulbagan branch, and my lord, such and such, another my lord, 5 lakhs drawn on Indian Overseas Bank as a security of rupees 10 lakhs. Subsequently, said Sujoy Ganguly paid rupees 10 lakhs by cash to the defendant. The plaintiff further received 7 lakhs only from the defendant upon execution of a written note on the backside of the said memorandum of understanding lying in the possession of the defendant. It is placed on record that there are two sets of memorandum of understanding. One is lying in the possession of the plaintiff and another is lying in the possession of the defendant. The defendant paid rupees 7 lakhs by cash. To that effect, an acknowledgement was made on the back lip of the memorandum of understanding lying in the possession of the defendant. It is made clear that the plaintiff received 10 lakhs only from Sujoy Ganguly and further 7 lakhs only from the defendant. In gross, the plaintiff received 17 lakhs. And out of 33 lakhs, therefore, the plaintiff is entitled to 16 lakhs 34 and the with principal amount and the plaintiff claims 8.
What is the amendment application?
Well, at page 21, schedule of proposed amendment, well, Roman 2, at page 5, paragraph 9 of the plaint, after the line 16, the following sentence shall be inserted that both the checks are not deposited with the bank for encashment at the request of the defendant, and Sujoy Ganguly, another check being such and such drawn on Indian Bank was also handed over to the plaintiff by defendant with Sujoy Ganguly. Said checks were taken back by them. Instead, thereof rupees 3 lakhs check amount was paid by cash.
Give me a minute.
My lord?
Give me a minute. This 10 lakhs was paid by check.
Check. But kindly come to my lord, page
Now
11.
their case is that you have taken back the check.
Very well. Kindly come to page 11. Once again.
Yes.
My lord, 1, 2, 3, 4, 5, 6. 6 lines from the bottom.
Yes.
My lord, subsequently said Sujoy Ganguly, my lord, prior to that, my lord, both
Where is your written statement?
My lord, said Sujoy Ganguly paid rupees 10 lakhs.
Your written statement dealing with paragraph 9.
My lord,
Show me that.
by cash to the defendant.
Show me your written statement.
Apart from check, my lord, he has also
Show me your written statement. Dealing with paragraph 9. What is the statement? You have not annexed the written statement.
No, my lord.
Give me your written statement. How you have dealt with paragraph 9. You have not specified that. How have you paid this 10 lakhs?
Oh, that's true. But kindly have a look at the plain case. My lord, plain
I've
case.
seen that.
My lord, two
Your
checks were
case is
returned back.
that he has admitted having received.
2 checks were returned back. Very well. But thereafter, subsequently, Sujoy Ganguly paid rupees 10 lakhs by cash to the defendant. Categorical admission. The plaintiff further received 7 lakhs from the defendant. Kindly have a look at the plain case.
Mr. Haldar, he is not trying to withdraw that admission because the earlier admission remains. Now he is clarifying that you have taken back those checks and you have not paid. So he is not deleting the earlier paragraph.
No.
That admission remains. You take advantage of that admission.
No, well, kindly consider this.
Mr. Haldar, you take advantage of that admission. He is not clarifying. He's not withdrawing the admission. Clarification is permissible.
But total amount received was 70 lakhs from the plain case still.
Mr. Haldar,
Even after amendment,
withdrawal of admission may not be permissible, but clarifying the admission, is it not permissible?
But from the
Where are those line of decisions?
But from the statement of the plain case, even after allowing the amendment, it still
That remains. Admission remains. He is clarifying that. Where are those line of decisions? Starting from Modi spinning?
77 Supreme Court.
Yes. But you are aware, Mr. Haldar.
But this is still today, that there is admission.
May I take by the copy of
Yes, yes. 41. Yes, Mr. Rai. হ্যাঁ না 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 ওটা দেখছিলাম মানে শুধু ডিপেন্ডেন্টের স্ট্যান্ডটা দেখার জন্য ইয়েস
The suit was filed.
ফাইলটা দিন ইয়েস ইয়েস মিস্টার
An
রায়
application under Order 20, where Rule 90 was filed for setting
Order?
aside, Order Rule 90 for setting aside sale. The property was mortgaged by the predecessor of the petitioner and the predecessor of the
Why
defendant.
took time on the last occasion? Did not. No time was taken. Yes, yes. Yes.
In such as loan was obtained. Subsequently, my lord, loan was not been paid. Proceedings was initiated. Mortgage suit was initiated. It appears that the predecessor of the petitioner was participating in that proceedings and degree was passed. Degree was passed on the basis of Solenama. Subsequently, the property was purchased by the predecessor of the defendant, who happens to be the brother of
Petitioner of the defendant. That is the predecessor of the defendant. That is the
and the predecessor of the petitioners are both the brothers. They obtained loan. Proceedings was initiated. Mortgage proceedings initiated at the instance of opposite party number
The
one.
third party.
No. Now after the death of the original one of the brother, their yes initiated proceedings for eviction. From there, I came to know, or my predecessor came to know, that this was the process initiated, and it appears that Bukalatam was filed by forging my signature, and the Solenama also contains the signature. It doesn't belongs to me.
So you have to apply for setting aside of that compromise degree.
Sale also. Sale. Accordingly, miscase was filed. Miscellaneous case was filed. In such a case, my lord, an injunction was paid for. Injunction continued up to 2017.
So this case was filed for setting aside of
the
the
sale. On the basis of the
not the Solenama decree.
not initially Solenama, they have admitted yes, this is the amount we have obtained.
Mr. Rai, if you have not challenged the not paid for
Sale, the sale, markedly consider the sale. I am challenging the sale.
You are not challenging the decree.
Whatever the amount it was declared, we as it may, I am not on that. The sale, whether a party to the proceedings was there, was a defaulter, can apply for purchasing of the same.
Is there any bar?
Yes, my lord, subject to question, my lord. Now, my lord, I filed an application that those degree was now signature was not belongs to my father, and accordingly, an application under Order 26 Rule 9 was filed. That was rejected by holding.
What is the application which was disposed of by
that in the Vokalatnama and the application, my father's names were appearing. And the documents which we had disputed that these are not the documents or the discharge letter in Garnishee the cell not belongs to my father.
So have applied for setting aside of the Vakalatnama.
Cell is cell, including all the possibilities. Well, can
Give
it down to my application order treatment.
Give me a minute. I will come back to you. So where is your application of 2nd of December 2016?
Yes.
That was rejected.
That was rejected.
Yes.
That your lordship will find page. Page 72. Page 72.
Yes, 72, yes.
You will also turn to page paragraph 3.
Which is the admitted signature?
The original application, the Wakalatnama, filed in the present miscase.
Miscase has been filed by that Mukta
Yes,
sir.
yes, yes. Preserved. And that is why, my lord, can you turn to why it was held? In one place, your lordship will find middle portion, my lord, the order impugned, second page, middle portion. My lord got it. Order impugned. On pencil of the case record, my lord will find on the middle portion, second page.
Second page.
Middle portion. On pencil of
yes.
It couple found that the Muktesha Pradhan was the one of the party to that proceedings. Since Jesus filed this miscellaneous case on the ground of fourth signature of his in the petition of for Sulanama, he has passed away on such and such. So from 1991, 1998, he has got enough time to file the petition for challenging the signature in his Vokalattama and the Sulanama petition, but remained silent and suitably hears also till 2016. My lord, pause here for a moment and satisfy your lordship. What are the proceedings pending? If that be so, then my lord, what is the reason? It is the premature.
That may be the, but what prevented him from taking
Yes.
this step from 1991 to 1998?
If your lordship can turn
time he was living.
That your lordship will find the initial order of injunction, which is page 82.
Show me the miscase.
Yes.
What was the ground taken?
No advertisement, nothing, on the basis of which everything was transferred.
It was stated that this Solenama was obtained by using the fourth signature.
Page 16. Your lordship can turn to page 16.
16.
16. The relevant portion which my lord is paragraph 4, page 21.
Mr. Rai, that Solenama was of 1967.
In the award proceedings.
Yes. So the admitted signature is of the year 2018.
1991.
1991. By the passage of time.
If that be so, my lord, passage of time, my lord, the execution. In the execution, apart from Solenama, the execution.
Also, during his lifetime, he did not take
Yes,
this.
my lord, can you consider why? That your lord shall find the proceedings after initiation of the proceedings, an objection was filed for the injunction. Page 82. I've already mentioned in the. This was initiated sometime in the 1991. My lord got it. Miss Appeal. Page 82.
Which Miss Appeal?
Injunction prayed for by the
Yes, yes, but this challenge.
Yes,
with
that was
regard to this
continuing.
comparison of the signature.
It was
he
LCR
did not-
was the, it is not that it is proceedings was continuing and I have not participated. This ended in the year 2007. After that, you will lordship kindly consider page 87.
Yes, which page you are placing?
Now, my lord, this was disposed of in the year 2007. 1991, it was
Yes,
disposed of 2007, next page 87.
page 87, yes.
One of the judgments delivered by Justice Amita Chatterjee, as his lordship then was. It was disposed of in the 2017. Prior to that, application was filed by the court below.
Yes.
And prior to that, my lord, the application was filed. It is not that the proceedings of containing LCR was there in the court of the learned decision in the Miss Appeal Court. 2007, it was disposed of.
That may have been. What prevented, because skeleton records will always be there. It's not
At
the
that point of the skeleton record, my lord, after this came after the computation, more or less, subject to correction, my lord.
in connection with the execution case.
No, this is the James case is order 20 rule 90.
Order 20 rule 90.
That is
So
why
if-
case. So entire process was continuing. That is why well, the entire LCR was sent down. But can you consider the order passed by the learned court of appeal below?
Yes.
Page 86.
86, yes.
Last question. The LCR.
Yes, yes. LCR may have been called for, but skeleton records will be there.
Well, the skeleton, if you logically consider the proceedings has been not been there. In the
So
court,
this miscellaneous appeal was disposed of when?
2007. They prepared a revision application before this court in the year 2007.
For that, the records were not called
That
for.
is why 2016 application was filed.
2016.
Before the disposal of this case, revision this case.
Yes.
Now, Manar, what if the fraud has been practiced? Manar, can you consider?
Mr. Rai, whether the signature of the Vakalatnama in 1991 or 1988, 1990, when you filed this in 1991,
1991.
James cases of the 1991 can be compared with a signature of 1967.
Now, this is after that also. If you lost
Your prayer is to compare with the signature in the Vakalatnama.
Well, it's 76. What is the objection taken?
Maybe the objection. But
if my lord is looking on the basis of the objection and equity, whether
not the equity, Mr.
Equity, the fraud has been alleged. Not only alleged, but it appears.
Fraud has been alleged.
And
but what is their objection?
Yes. Can you turn to?
There is no scope for referring to before the document is tendered in evidence.
Yes.
Which document is tendered in evidence? The Solemnama decree.
That is the basis.
Yes.
So they said at the time of evidence, it should be tendered. At that point, you can raise this objection.
No, that even assuming that may not be the real ground, but the question is whether a signature of 1967 can be compared, and more so the petitioner was present at that point of time.
At least 2007, the documents are there before the court below, indicating the signature of the person because he has participated in the proceedings. and it was there in 1967. Whether that is, if there is any discrepancy, that can be pointed out by the expert itself. No, it cannot be compared because of the length of time. Whether anything defendant did not come forward, said that it is premature, and the court will have rejected my application by holding in the year 1991 he did not apply for the same.
By the order impugned, the for evidence.
Yes,
Evidence
Malar Kali, once Malar, otherwise this is something.
mention if it is.
Malar Kali, it cannot.
Yes. Call the next matter.
Malar Kali, kindly consider if Malar is privacy admitted and Malar, whether the Solenama in Garnishee arbitration proceedings can be challenged. Can be challenged there. It is not a Solenama in a suit. The arbitration proceedings. It is a cooperative act. Arbitration, that award is subject matter of execution.
All right, come if it is, if proceeds.
Malar Kali, so it can be decided. Otherwise, the pendency of this same Malar, it will be nowhere. If the execution is continuing, Malar, what will be the effect?
It's the miscase execution.
That is the miscase.
Evidence.
Miscase evidence. That is the thing. I want to bring that. Otherwise, Malar, it will be futile exercise, Malar.
File ta din.
Otherwise, it is futile exercise because, Malar, if the evidence is going on, and that is the case for which
evidence is fixed sometimes in the month of April.
And Malar, we are in the month of March.
Yes.
And Malar,
12th of what happened on 12th of March?
At 10-4. 10-4. 10-4. We have filed this application. I prayed for an adjournment.
Yes. What is the next date, please?
10-4. 10th April.
My.
So, Malar, can allow us to take adjournment there? Will not.
There shall be an order of stay of all further proceedings in. Yes.
I am for the petitioner, my lord.
Yes.
I am for the petitioner. My lord, in city civil court, a partition suit is filed. The total valuation is 8 crores 97 lakhs 60,649. My lord, the pecuniary jurisdiction of city civil court is 1 crore, my lord. By filing this,
which is the order under challenge?
My lord, the injunction order, my lord.
Order dated? Order dated 18th of October.
18th of October. Yes, my lord.
It's an appellable order.
34.
43.
34 plus 6.
No time fix everything.
Yes, I'm sorry.
Yes.
Mr. Mukherjee is addressing the division bench.
So what do you want? On his prayer, it has been fixed at 3:30.
If Lordship permits, I can address you.
Yes.
Oh. Sir, may I make this request to your Lordship? He is arguing before the division bench, courtroom number 8. If in that case, if Lordship would kindly allow us to come back tomorrow.
On the prayer of an accommodation has been paid for on the ground of Mr. Mukherjee.
My lord, this matter, I have challenged the order passed by the State Commission Consumer Court.
Appeal lies.
So I'll tell you, Lordship. It is not on contest. My appeal has been rejected only on the ground and that the learned advocate appearing for the appellant chose not to argue the matter as he had no instruction from the client.
Your advocate.
Your advocate. No letter to me, no intimation to me. Lordship, you just kindly see the order. I'm so sorry, Lordship, because that is why I'm trying to invoke the jurisdiction of 227. Lordship, we kindly see the order passed by the State Commission is appearing on page 109.
109. But you could have filed an application for recalling.
Lordship, what happened thereafter? Execution case was filed. I came to know from the execution case that this order has been passed. Can you see the first order, Lordship, page 109?
Yes.
Number 2. At the time of final hearing of this appeal, learned advocate appearing for the appellant appeared and declined to make argument as he had no touch with his client. As such, the argument on behalf of the appellant was closed.
Oh, this is an appeal.
This is the appeal in the State Commission.
Not a original proceeding.
No, original proceeding is ex-party.
So,
Ex-party order passed against me.
Against that, there is a provision of revision only.
No, there is a provision of National Consumer Court.
Revision, not an appeal.
No, not appeal, revision. Correct. Correct. But here, what happens? There are. I'm fortified with some judgment of our Supreme Court also, where if it is found that if natural piece of justice or if there is a order which does not spell out.
Could have filed an application for recalling of this order.
Lordship, it was too late. The execution was filed. After coming to know about the execution, I wrote a letter to my learned advocate also, previous advocate.
2022.
Yes.
So now you are challenging in 2025.
No.
After 3 years.
Not 25. This was filed in 24. It was not coming in the list we mentioned.
For 2 years. Even then.
Lordship, that is the situation.
Right. So 2 years.
But I was not informed. Lordship, I was not having the knowledge.
Delay.
Lordship, delay. I have explained that I was not. My advocate has not informed me. I have written letter to my advocate also.
What is the stage of the execution?
Execution, Lordship, I have appeared. What
was the order passed by the district forum?
The district forum, Lordship, just give me 2 minutes time, Lordship. What happens that I am being projected as a developer of a property. The person is an intending purchaser. Now he enters into an agreement with me in the year 2014. And he wants to buy a 700 square feet flat from me. According to him, he pays the money in cash, which I dispute. In 2014, he pays some money in cash. Now, thereafter,
according to you, he has not paid anything.
No, all the receipts are not genuine. So but I could not contest the matter because they tried to show that they served, but I did not receive any copy. And the district forum passed the order ex-party against me. After coming to the ex-party order, then I preferred an appeal. In the appeal,
you did not contact with your learned advocate.
This is what he has said.
Shows the conduct of your client.
Lordship, we also see the conduct of the advocate. Lordship, judgment 2008. Suppose if my client does not contact me.
What will the advocate do if the client does not does not keep contact with him.
Lordship may kindly appreciate, he will intimate me. It is his duty when I wanted
It's
him.
not the duty of the client to keep contact with him.
Definitely. I'm not arguing on, I'm not debating on that point. But Lordship, not a single piece of paper, not a scratch of information given to me. And he simply goes even without my instruction and says, I will not argue. He could have retired from the brief. He could have said, I'm giving my no objection. I'll not appear. My fees has not been paid. Whatever is there. He is governed under Section 35 of the Advocates Act. Nothing done. Kindly see, I've given a letter to him on 24 page 111. No response to my advocate's letter also. I've communicated to both the advocate. What have you done? Why didn't you inform me? What was the problem? No, nothing was discussed. These letters have been received by the previous advocate. Page 111. I've annexed it in
What is the stage of the execution?
Execution, they are asking for because the district court said that, okay, see, this was unregistered agreement.
What is the order passed by the district forum?
That is there, Lordship, kindly come.
Page?
The order is filed, just a minute. Page, Lordship, 47.
47?
46. And Lordship, this is time bar also. The consumer court has passed the order without taking into consideration that this was filed after 4 years of the cause of action. Section 24, capital A of the Act says it has to be filed within 2 years of the cause of action, Lordship. This was not even looked into by the learned court.
So you are directed to refund 14,50,000.
Yes. And along
and
with
2 lakhs compensation, 10,000 cost.
Correct. Time barred. Cause of action took place in the year 2015. He filed the case in 2018. And thereafter, after coming to know about this thing, I filed an appeal. And in the appeal, the learned advocate goes and says that I have no instruction, I will not argue.
What is your case made out in the appeal?
Lordship,
with regard to the agreement?
Lordship, I'll tell you, Lordship. The appeal is page 63.
You have not filed any application along with this memorandum?
So there, this is memorandum is only filed, Lordship. This is the way they proceed. This is what they have
memorandum will contain only the grounds. What is your case made out?
Lordship,
merits.
Correct. Is the application here? Huh? No, this is the appeal you have filed. Where is the stay application? Lordship asking for the grounds in the stay application.
Yes. Because you have been directed, according to them,
this
he has paid 14,50,000 out of 17 lakhs and odd. So he has directed you to refund that.
Lordship.
So what is your case?
Lordship,
how much you have received?
In the grounds, we have taken the point that on the facts and issues, Lordship, this money receipt they are showing, Lordship knows very well.
Some of the money receipts, according to you, are not genuine.
Lordship.
So what is the quantum of the genuine money receipts?
Correct, Lordship. Now, only thing, Lordship knows very well, when there is a disputed question of fact in the consumer court, is a summary proceeding. Then the matter is generally relegated to the civil court. You take it on, matter is relegated to the civil court. Consumer court will not.
Civil court?
Yes.
Efficiency and service.
No.
Consumer forum can.
In the consumer forum, just few minutes
now
back,
there is no dispute on facts because you have not been able to show anything, any pleadings of yours disputing that fact. Till now there is no dispute with regard to facts.
That I will raise at the time of when I will be given an opportunity to go to the appeal court and raise my points there, Lordship. My appeal has
what
been
have you
dismissed.
stated here on
My
your
appeal has been
on your
dismissed.
merits in the revisional application? What is your case on merits?
Lordship.
Sir, a poor purchaser have paid a certain sum of money. You have not given possession of the flat.
He has not
You
paid
will
the
also
entire
not
money.
refund the amount.
He has not paid the entire money to me.
Maybe some amount has been paid. Say what is the amount he has paid to you.
That is true, Lordship. But
so
50,000 is the initial payment he has paid. But there is 14 lakhs, my client has disputed that.
So only 50,000 he has paid.
That is, we have admitted 14 lakhs because that is in the part of the agreement. He is subsequently showing 14 lakhs cash at one time in a receipt, which we are disputing that. Which have taken my original application, paragraph have said that. Now, only thing, Lordship, I am just praying that I should be remanded back to the appeal court, Lordship, to canvass my, whatever is my argument is there, Lordship. My advocate has simply said that I will not argue because no contact with the client. This cannot be allowed. Lordship, 2008 Supreme Court says that the advocate cannot be allowed to do that. Even if the client is not in contact, he has to do some more work. He has to give a letter to the client expressing is that I will not appear in your court. You have not paid my fees, whatever is there. Lordship, this is the judgment of Supreme Court in this point.
You are Bhattacharya Enterprise.
Yes, Lordship.
Are you disputing the money receipt at page 27?
Yes. Page 27, 14 lakhs rupees.
You are disputing this.
The notary public, the advocate, I don't know anybody. It was not done in front of me. Nothing has been done.
Who is Mousumi Bhattacharya?
She is my, we have taken divorce. We had a matrimonial dispute at that time. So she was also putting all sort of pressure upon me at that time.
But she signed in the money receipt also.
Lordship, she has signed.
Disputing her signature also.
She has signed or not because at that time we had a very in a very bad relationship, Lordship, with my wife, and we have subsequently taken a divorce also. 498 proceeding has been started against.
What is your ground in this revision application with regard to this money receipt? Any
Lordship,
statement with regard to this?
Lordship, I'm showing you. I've taken that point. Paragraph 5. I've denied a
And did you give any reply to the letter
we have
dated
not received the
15th?
letter, Lordship. That is
Not
my
received
case.
the
Ex
letter.
parte decree. Ex parte order.
No. This letter at page 29, which you have annexed.
These have taken from the record.
I'm asking you, have you
No,
received
no,
this
I have
letter?
not received this letter.
You have also not received
No.
this letter.
No copy was served upon me about the letter or any application of Bureau of Consumer Court. Entire thing of the certified copy. Can you see the application? The previous advocate did not give me any documents to me.
Have you annexed the, have you obtained all the order sheets of the district forum?
Yes, Lordship.
Where is that?
Order देखो कहाँ पर है? No, the order of. Show you. Tell me the page. Yes, Lordship, we get it from page 72. In fact, page page 71 onwards.
Have you taken steps against the advocate?
I've given a notice to him. I've given a letter to him. Page 111.
You have given a notice to the advocate?
Yes, page 111. No response to my letter.
Your wife was looking after this case on your behalf?
No. We had a strained relationship.
By the order impugned, the first appeal before the State Consumer Dispute Redressal Commission stood dismissed. Full stop. Paragraph, petitioner is directed to serve a copy of this application upon the opposite parties by registered post with acknowledgement due and file an affidavit of service on the next date. The point of maintainability of this application
petitioner where my lord, I am appealing on behalf of the defendant.
opposite party.
This is the rejection of my lord amendment application, my lord, by the learned court below.
Yes. You have been served with a copy.
No caveat.
Caveat is there.
Oh, caveat.
You have served.
Yes. Caveat, yes.
Yes.
Well, kindly say impugn order. Caveat. Applicationটা কত পেজে?
Where is your plaint?
Plaint, my lord, first annexer, my lord, page 10. Actually, I came to know from the evidence of the DW1 that his father was tenant. Then and then I filed application for amendment.
You are the plaintiff.
Plaintiff. But I purchased the property 2002, my lord. My lord. Before that, he was a tenant. I filed 82. Tenancy was created. My lord, I filed an eviction suit. But during the evidence, my lord, I came to know that the defendant number DW1, my lord, admitted that his father was tenant. That's why I filed this application. This is a part of the record, my lord, evidence. In February 2024, I came to know. Evidence type. Yes.
Where is your application for amendment?
Page 20. Though it is not properly drafted, my lord.
How can you delete this? How can you delete this?
Because, my lord, why, my lord, I prayed for amendment, my lord.
This is withdrawing the admissions.
Already admitted, my lord. The defendant admitted in the cross-examination that his father was tenant.
You can clarify that, but you cannot withdraw the admissions.
Like clarification, my lord.
This is not clarification. You have withdrawn that he was the premises tenant.
Instead of tenant, my lord, the trespasser.
My lord, I have a judgment, Supreme Court. Last paragraph. Order. Well, after 4 lines, we also satisfied that she failed to substantiate
inordinate delay in filing the application.
At what stage?
After closing of evidence.
Evidence.
Evidence has closed. After
Evidence, because I came to, my lord,
fix the date for
I came to know on February 2024. Immediately I filed it. Immediately I filed it. There is no delay.
Kindly see the evidence examination.
Kindly see the cross examination of the DW1, my lord.
Kindly see the exhibition chief of plaintiff. Plaintiff, exhibition chief. Kindly see the 1, 2, 3, 4, 5, 6, 7 paragraph, first page. Defendant become the premises tenant under me.
This is in tune with the original plaint.
This is the exhibition chief.
Yes, yes.
And not only that, after notice, he has admitted that I am the tenant.
Examination chief is only the plaint.
Yes.
From the plaint.
So at the stage of evidence, where is your explanation for the delay? Nothing has been stated.
Explanation, my lord,
after
admitted that some, my lord,
This application is
for
the
drafting,
instance of
but it is admitted.
you have made out a case of reasonable requirement. Is satisfied with that. This application under Article 227 of the Constitution of India is at the instance of the plaintiff. চারটের সময় ফিক্সড আছে, তখন 4টের matter. Yes, upgraded matter, anyone which cannot wait till tomorrow?
Lordship, tomorrow is the next date for hearing in the court below.
Tomorrow is the date fixed for?
Argument in court below. The next matter, Your Lordship. I don't know 45.
Call the next matter. Who is appearing? You are appearing in a 4 p.m. matter. Yes.
Lordship, it's the order impugned is from an application for amendment of the schedule of the plaint, Your Lordship.
Order 6, Rule 17
Yes, Your Lordship.
of Section 7172.
No, Your Lordship. Not of 7170, Your Lordship. Of the schedule of the plaint, Your Lordship.
Schedule of the plaint you want to amend?
Yes, Your Lordship.
Why?
Lordship, because the tenancy came from.
Where is the plaint? Madam, you have not annexed the plaint. You have not annexed the application for amendment of plaint.
My mistake, Your Lordship. The application for amendment is, Lordship. Lordship, the application was rejected on 2 grounds, Your Lordship. Number 1 is the notice. The notice did not.
Where is the plaint?
Lordship, may kindly pardon me, Your Lordship. I do not have a second copy of the plaint. Can I? Lordship, I'm covered by 2 judgments of one of our Honorable Court, Division Bench of our Honorable Court, and one of the Supreme Court, Your Lordship.
Copy of your eviction notice.
Lordship, but it has been, it is there, Your Lordship, that.
What is there? Show me your eviction notice.
Lordship, the eviction notice states that it has the 1 room on the 2nd floor, Your Lordship. But I'm covered with the judge of by a judgment of our Honorable Court, Your Lordship, a Division Bench of our Honorable Court.
Madam, are you aware what you are trying to do by way of this amendment?
Lordship, I'm just adding 1 room. Lordship, the eviction notice.
Madam, if the prayer for amendment is allowed, what will be the effect on the notice?
Lordship, that is why I'm covered by a judgment. My Lord, kindly look at it.
You have a copy of the notice under section 6(4).
Lordship, I'm not carrying a copy of the notice. Lordship, may kindly come to
Which paragraph?
paragraph number 10, Your Lordship, page number 422. May I place it, Your Lordship? Law is also settled that it is well known to the tenant as to in which premises the tenant has been enjoying the right of tenancy, discharging his obligations, payment of rent for months or years together by maintaining other terms and conditions of the lease, if any. So the appellant enjoying so far his tenancy rights now in the status of statutory tenant, the self-same premises is not entitled to dispute on the plea that the respondent is not entitled to get a decree of eviction for lack of description in states, including its area, in the plain schedule in respect of the premises. when we find that the lease was admittedly was pertaining to rule number 40 to 44 of the third floor of the premises. In the Lordship, next line, Your Lordship, non-mentioning of rooms with area of the suit premises in the notice to quit or non-mentioning of the area of the suit premises in the plain schedule or discrepancy or mistake in giving exact area of the rooms in square feet during the oral evidence by BW1 are not fatal to the case of eviction, which is liable to be determined under some special statute. The purpose of notice to quit is to notify.
So you take help of this judgment in the time of final hearing. Place this judgment saying that then amendment is not necessary. Why are you applying for amendment?
Necessary for the
Because this judgment takes care of that. Tenant knows the extent of the tenancy.
Lordship, but the amendment is necessary for the execution purpose, Your Lordship. The execution is based on the schedule, Your Lordship.
Tenant knows the extent of the tenancy. That is the judgment. You take help of that. Take help of that.
Lordship, kindly.
It is
Lordship,
not an amendment.
I'm covered by a Supreme Court judgment, Your Lordship.
Madam, you may cite Supreme Court judgments, but kindly come to your plaint. First, the plaint paragraph 2
Yes, Your
will
Lordship.
be contrary to the amendment if it is allowed. Kindly consider this.
Lordship, I've sought an amendment for both paragraph 2 and the schedule, Your Lordship.
Rent part will remain same. And the
Lordship, let me tell you.
show me your evidence.
Lordship, Lordship, this is the evidence, Your Lordship. I received the copy only in November 2023. Sorry, Your Lordship, November 2022, because the evidence was tendered on 14th of January 2020.
No, this is the evidence of the defendant. I'm asking your evidence, plaintiff's evidence.
Lordship, I did not have a copy of the agreement. Lordship, this tenancy is going on since last 50 years. Lordship, there was one joint family. From there, several tenancies accrued, Your Lordship. So they, the agreement that this tenancy was based on was with the tenant. I did not have, it was only after the evidence was tendered, I came to know, Your Lordship. And the advocate for the plaintiff who was appearing in the court below, he passed away during the COVID period. So only after the COVID was over, a new advocate tendered his wakalatnama and with
So you came to know of this fact from the written statement.
Hey, Lordship, I came to know from the written statement, even the 7172 application was there. This fact was there. But
So why you filed this application at such a belated stage?
Lordship, because there was no evidence regarding that, Your Lordship. Lordship,
Thank you, ma'am.
Lordship, the agreement they were banking on. Lordship, let me place the Supreme Court judgment as well, Your Lordship. Lordship, paragraph number.
You will not rely upon the judgment I have delivered relying on this. I have delivered relying on this. Misdescription in the property that can be allowed at any stage
Lordship, my
because it will result cause trouble at the time of execution. I think that is the proposition of law laid down in this.
Yes, Your Lordship, and also that at a later stage also. In this case also, it was a very late.
Any other Supreme Court judgment you want to rely upon?
Lordship, just these two, Your Lordship.
Thank you. This application is at the call the fixed matter.
Lordship, if I may get the plaint back, Your Lordship.
Plaint, please take after the order is.
25.
Yes.
My lord, we had concluded our submissions. My lord, this is that order 9, rule 13 matter.
Which Banerjee? Yes.
It's matter that court will tomorrow.
An accommodation has been paid for on the ground of Mr. Banerjee, learned senior counsel, appearing for the opposite party. Full stop. List this matter under the same heading in the next week. Yes, next. Chatterjee, you are appearing.
76. What is the 76? 76.
Nothing with the 46 passport.
Yes. My lord, my learned senior friend, Mr. Trivedi, on the last occasion was a hearing matter for 7 minutes. I don't know, my lord.
So Chatterjee, it's difficult. Let it appear under the heading contested matter because it's a hotly contested matter. Because
my problem is, my lord, that my
because this is
construction
a
is stalled.
hotly contested matter, it cannot be taken up because some upgraded matters, urgent matters are there. Those are to be.
That is exactly why your lordship, my lord, fixed it here.
Yes, but
because
it's difficult because it's a contested matter. I am fixing it under the heading contested application because it
It'll
cannot
never
be
heard.
in the motion
Your-
stage, Mr. Chatterjee.
At
It's
least
very
for
difficult.
10 minutes, at least, my lord, by 10 minutes, my matter will be heard out, my lord, in 3 or 4
10
days.
minutes, Mr. Chatterjee, it's difficult for the court. I will not be
I-
able to.
I will not allow it
to
I will
remember
assure-
anything. I will forget.
I assure your
I have
lordship,
a very
my lord,
short memory, Mr.
I
Chatterjee.
assure
You
you,
know,
that's why, my lord, every day if your lordship hears for 10 minutes,
because
there's
you,
there's
you
a
have to leave other matters and come at 4 p.m.
I am
It may not be-
very, my lord, available. I'm extremely, my lord, not busy. I am completely before your lordship, my lord. I am not Mr. Rai and I'm not Mr. Mukherjee. I'm no one, my lord.
But you are Mr. Chatterjee.
I am very, very, my lord, available. I'll give me 2 minutes. I'll tell you, lordship, why I'm pressing.
Mr. Chatterjee.
Is there. 2 minutes is there. Have a look at the impugned order once. Have a look at it.
Mr. Chatterjee, it cannot be finished within 2 minutes.
Cannot be finished. But I'll give you, lordship, an outline and tell your lordship why I'm, my lord,
It will help you.
It might not.
I can record that even without giving that brief outline. If it helps you,
I don't even get blood. Your lordship remembers Mr. Dasgupta in courtroom number 13. It remembers what was told to him. My lord remembers that story. His order 41 was called up at 4:25. He started. Then courtroom number 13 in 2001.
yes.
Said,
Not now. Yes. Yes, that I remember.
The answer was তোমাকে উপরে যেতে কে বলেছিল? So similar is the situation here,
No,
but it's just the other way around.
For that, I can record. I am not saying that. If you say that, I can record that you have started. But Mr. Chatterjee, the only difficulty is.
I'll tell you, lordship, why I am pressing for this. My construction has gone up to this level. After this, without even a walk-off deed, the walk-off deed says prima facie it's a walk-off property.
Mr. Chatterjee, I appreciate, but it has to be hard in extent.
Fixes a date, I have no problem.
That is the difficulty.
That's any day, your lordship.
So at 4 p.m. every day, I think Mr. Banerjee is also waiting from one of the 4 p.m. fixed matters. That is the difficulty.
Lord keeps it for tomorrow. Let us see what happens tomorrow.
Pass over next.
7.
Same, it's not big. Pass. Except that I have some difficulty tomorrow. Instead of tomorrow, it would be day after.
Next week?
Next week.
Who is opposing you?
He will oppose. So instead of tomorrow, next week he will oppose.
কি ভাবলিও এমনি অপোজ করবো নেক্সট উইক হলে অপোজ করবো
This is DRT matter.
DRT Sarfezi, one short question. No, I'll just अच्छा बोले ना.
We made that prayer there, but the tribunal says that unless this matter is heard, will not take up. But the order, the last order, my lord, specifically says that the essay should not stop. It should proceed with the essay. There is no stay with the essay. This issue would be only dealt with process. I have a due of more than 6 crores. Now, my lord, if that continues, that is the difficulty. I have
No, no,
tried
so
to
instead of, when no one's resisting a hearing, instead of tomorrow, instead,
What there is resisting because of this maintenance.
no, no, that's all, Ramanan. Instead of tomorrow, I'm saying day after. Day after.
The day after I won't be there, or maybe on Thursday.
Thursday তো ওখানে ফিক্স করালে তুমি
না, for a Friday.
ফ্রাইডে হ্যাঁ Thursday.
As jointly prayed by the
Then it's all right.
Banerjee, if you have not solved, do it in the meantime. Just call the next matter.
Great.
Addressing your lordship, my lord. We left at 3:45 today, my
It's not feeling well.
I mean, you're saying that if it can be taken up tomorrow, my lord, it was already addressing your
Of
lordship.
course. Not today. I'm not passing any order. Only not today. Only thing is that you do not know when to be taken up. That is the difficulty.
Tomorrow lordship fixed two other
It appears,
matters.
but
It did good day after.
the motions are there, so you
I
are
appreciate.
waiting. I watched you are waiting since long, but it's the difficulty.
Tomorrow lordship fixed two matters. I was praying if it can be day after.
Day after. Let it appear. If you have any difficulty,
Well, we'll be here.
My lord, may I have your lordship's kind indulgence, item number 49. My lord, may I have your lordship's kind indulgence, item number 49, appearing under heading upgrade motion.
Yes.
Led by Mr. Raja Chaudhary, Raja Chatterjee, he's a learned senior
My
counsel.
lords, I am appearing. I understand, my lords, as your officer, I understand the board is heavy. All I was praying, my lords, if a short date I can be accommodated.
Tomorrow it will appear.
I am grateful, my lords, but my only problem is this matter is showing
not
up before.
tomorrow. Day after tomorrow, because tomorrow the monthly list will be taken up. So it will appear day after tomorrow. Can you not wait till day after tomorrow?
My lords, as your lordship pleases, my problem is the appeal before the SEBI Appellate Tribunal is also coming up.
When?
That is coming up day after, my lords.
Yes,
19th of March. My lord, I will take my chances if your lordship may hear me on day after. I will
Yes.
somehow try to take that out.
And your lordship, on the previous occasion, your lordship had granted us a direction to file a supplementary affidavit.
File it on the next day.
My lord,
I'll
it's been
put up
filed.
on the other side.
No, not yet. I'll take instructions.
You are for the
I'll take instructions, sir.
yes. So file on the next.
On the matter is on the Wednesday, the date before the learned sat. So the matter should be, if your lordship kindly indulges, if it's on the top of the list and only
Upgraded after the motions, it is taken up. It has been upgraded. It cannot be further upgraded. It has been upgraded considering your
As
urgency.
your lordship pleases. No, we are your lordship, and we will try and take.
List. So the motions, first time motions has to be given preference. These have been upgraded from the monthly list. Considering your prayer for urgency, cannot be upgraded further. Yes.
Oblige, my lords.
Next matter, Mr. Rashad Vidura was arguing, with respect to the Section 8 application, which was allowed by the court. And
What is your item number?
the 770.
79. Yes.
But I believe not he is yet to complete his submissions. Otherwise, not I could have not given a rejoin. It's not clear.
Let it appear. The next day you take your chance.